Matter number 1, CRP 57, Federal Information Pressure, Draft.
Revision petition dismissed.
Obligation.
Lordship, I would like to mention item number 7 and 8, Your Lordship. In this both cases, Your Lordship, AG will be appearing, Your Lordship. He's not available today, so
Item number 7.
7 and 8, Your Lordship. Matter may be fixed on 16th of this month, Your Lordship.
16.
16th, Your Lordship.
On the affair being made by Miss
Arbasar.
Learned Council Product. Respondent.
Yes, Your Lordship.
You obtain consent from the other side.
Yes, yes.
Consent from the other side. Respond listing the matter on 16th of December.
December.
Here.
Right.
Lordship, may I like to mention one criminal appeal pending matter that may be fixed for hearing for day after tomorrow on 5,
Which year?
2024
Appeal.
appeal
When do you want?
for hearing
When?
on 5th, day after tomorrow. Maybe on Monday also it will do.
Next Monday?
Yes.
Okay.
Matter number 1,
May please, madam. Madam, here the repeated file challenging the order of the learned and can't got against madam. Madam, in connected matter, in my lord has appeared for the respondent
Oh.
for
Son. It's not on record but here.
it's on the court matter.
It's here.
Yes.
Yesterday, I thought I know the issue, but I did not see my name. in it.
Mostly will find page 102, my lord. For some of the-
Division bench order.
No, yes, my lord. In the writ petition, my lord. Of the writ petitions, my lord. Kindly see page 109, my lord.
109.
It's a series of writ petitions we were filed, my lord, against the
Oh.
repetition order.
But in this matter, I did not appear. In another matter, I had appeared.
Then, my lord.
It's okay.
Okay. Let's just list this matter before appropriate bench. Without one of us.
matter number 2,
Depends on division legislature. UDA election. That will division of the division legislature. It was Sir, I was saying to 356 40 notices. Okay, good for that. It was, yeah, okay. There are also similar. Similar.
Similar matter, my lord, there's a direction from the principal seat that it should be clubbed together with this.
We have. It has been registered.
I don't know if the records have reached or not.
Otherwise, my lord, those writ appeals were filed by the, my lord, the officiating promoters, my lord, who were given officiating promotion as a assistant engineer against the direct recruitment quota vacancies, my lord. And my case is slightly different, my lord. I was given, my lord, officiating promotion in a deputation vacancy, and subsequently those deputations were permanently absorbed in another department, my lord. And they were also promotees, my lord, in the parent department, my lord. My lord, and my lord, the findings of the learned report is that, my lord, admittedly, their finding is that there are 14 vacancies, my lord, from the year 2008 to 2012, my lord. And by a DPC, my lord, 11 persons were given promotions, my lord, of which, my lord, by a DPC, my lord, ignoring me, my lord, I am one of the senior most, my lord, after that DPC, my lord. In the said DPC of the 2012, my lord, my lord, deceased person was also considered and recommended for promotion, my lord. And my lord, serial number 10 and 11 of the DPC of 2012, they were, my lord, juniors to the, my lord, the present appellants, my lord. They were also given, my lord, promotions, my lord.
Direct recruitment promotion of lower good promotion. So that vacancy direct recruitment quota to a successful quota to quota in so I am looking at
Yes.
My lord, and lordship will kindly see, my lord, paragraph, my lord, 36 onwards, my lord, of the judgment, my lord, page 161, my lord. 161. 161, my lord. Well, the very genesis of the, my lord, filing of the present appeal is that, my lord. My lord, kindly see the, my lord, page 161, the first DPC which was held on 2012, my lord. I am kindly drawing your lordship kind attention, my lord. Page 161, my lord. Fourth paragraph, my lord. On perusal of ACR, it is seen that the ACR in respect of Sri Tajong Mesa for the period such and such are not available. Only his ACR for period of such and such is available. However, the officer had expired in the month of September 2012, my lord, 11, my lord, and DPC was held on 24/7/2012, my lord. And my lord, kindly see the table, my lord. The DPC therefore recommend regulation of the officiating appointment of the old age referred to above retrospectively with effect from the date of respective officiating promotion as shown below, my lord. Serial number 4, my lord, is the deceased, my lord, Tajong Mesar, my lord. He was also recommended for promotion, my lord. And my lord, the next page, my lord, page 162, my lord. Dinga Ete, my lord. Dinge Ete, my lord. Who is that, my lord? Serial number 231 of the seniority list of the junior engineers, my lord. And Purpa Wangyan, my lord. 233 of the seniority list, my lord. I am at, my lord, 230, my lord, of the seniority list, my lord. I will come to the seniority list also, my lord. And, my lord, now, my lord, kindly see the, my lord, the findings of the learned single bench, my lord. Paragraph 29, my lord, of the, my lord, judgment, my lord. May I read, my lord? My lord, always seen, my lord, by DPC, my lord, page number 376, my lord. By DPC of 2012, my lord, only 11 persons were recommended for promotion, including, my lord, one deceased person and 2 juniors, my lord. On consideration of the submission of learned staging council, it appears that between period 1/4/2008 to 31/12/2012, there were total 36 posts of assistant engineer electrical available. Perusal of the minutes of meeting of the DPC dated 24/7/2012 reflects that there were 8 backlogs for direct recruitment quota due to conversion of 8 direct recruitment quota for promotional posts. Deducting 8 backlog posts for direct recruitment, the total vacant posts were 28 posts. Arithmetically, as per rules, 14 vacant posts, each of 14 vacant posts, each for the direct recruitment quota and promotion quota were available between 1/4/2008 and 31/12/2008, my lord. Admittedly, my lord, 14 posts were there, my lord, for my lord, the promotional quota, my lord. And by DPC of 2012, my lord, only 11 were recommended, my lord. And in the state DPC, my lord, the three, my lord, deputies who were absorbed in the another department, my lord, that posts were also not, my lord, taken into consideration in this DPC held in 2012, my lord. There, my lord, next line, my lord. Therefore, the posts were filled by means of promotion to the seniors of the petitioners, my lord. And saying that, my lord, these 12 posts were filled up by the seniors of the petitioners, my lord. Whereas it is factually not correct, my lord. Yes, because, my lord, my lord, with retrospective effect, which from the date of officiating promotion, that is such and such. Now, my lord, paragraph 13, my lord. My lord, paragraph 30, my lord, 4 lines bottom, my lord. Therefore, the petitioner number 1 accept the petition, therefore, the petitioner accept the petitioner number 1. Petitioner number 1 is the present appellant, my lord, who were promoted on assisting basis as extended against the quota mentor direct recruitment, stands terminated and discontinued on selection made by the Arunachal Public Service Commission and continued upon the direct recruitment. These were, my lord, the rest of the petitioners, my lord, who approached this report along with me, my lord. Perusal of the minutes of the DPC dated 24/7/2012 clearly goes to show there were no promotional vacancies and state respondent had accorded one-time relaxation for conversion of 8 posts of assistant engineers meant for the direct recruitment and recommended the names of junior engineers, namely Tajam Mesar, my lord. He, before the DPC, he is died, my lord. Nida Maksa, my lord, Sir, and my lord, Binge Ete and Purva Vangal, my lord, who are, my lord, below the seniority, below the seriatim of me, my lord. My name appears as serial number 230, my lord. For promotion to the post of assistant, which were meant for direct recruitment, and further recommended the name of the 3 others for promotion to the post of electrical engineer. Thus, there appears no vacancy for promotion as 8 junior engineers were promoted after conversion of 8 posts of assistant engineer which were meant for the direct recruitment quota. And my lord, paragraph 34, my lord, paragraph 36 is also important, my lord. The principles of next below rule were considered here, my lord. May I read, my lord? Page 380. Having regard to the having regard to the submission of the learned counsel for petitioner, that it is settled portion of law that if the initial appointment is not followed by a procedure laid down by the rules, but it continues in the post unregulated regulation of services. According to the rules, the period of service shall be counted from the date of appointment, not according to date of confirmation of the. In my view, is absolutely inapplicable in the present case. The other submission for the direction to promote the regular the petitioner to the post of assistant engineer elected by following the next below rule is totally misconceived and fallacious as the next below rule as rightly submitted by learned counsel for the private estimate in service prudence is a proposition which seeks to ensure that if the junior employee is given promotion without considering his senior, then the senior employees can claim the right to be considered for such promotion with effect from the date on which juniors was so promoted, whereas no juniors to the petition, whereas when the finding is whereas no juniors to the petitioner have been promoted in the present case, my lord. My lord, may I kindly for time being, my lord, may peruse the my lord seniority list, my lord, at page 67, my lord. That's page 67, my lord. My name appears at my lord, serial number 230, my lord. And my lord, the juniors who were promoted, my lord, by DPC held on 2012 are, my lord, at serial number 231, Bingate, and serial number 333, Purpa, my lord. 331, Bingate, and 333, Purpa, my lord. They were recommended for promotion, regularization, my lord, by the DPC held on 2012, my lord.
Serial number?
Serial number, my serial number is Marto Kambo, serial number 230. And my lord, the juniors, my lord, who were promoted, recommended, my lord, promoted with retrospective effect is 231 Bingete and 233 Fupasering, my lord. Ultimately held by the court, my lord, that there were no vacancies for the promotional quota, my lord. However, my lord, there is a, my lord, rider in the judgment, my lord. Kindly see at page, my lord, 77, last paragraph of the judgment, my lord. May I read, my lord? However, considering the state respondents had taken a stand that there were vacancies and attempts had been made to consider the grievance of the petitioner, although not materialized due to disapprove by the competent authority, dismissal of the writ petition could not preclude the state respondents to have a relook strictly in accordance with the law, my lord. And thereafter, my lord, after the passing of the judgment, my lord, they have, my lord, considered, my lord, considering my case, lordship will find at page 177. Oh, page 77, my lord. Sorry, my lord. There has been process initiated by the department, my lord. Page 75 onward, my lord. And my lord, page 76 is important, my lord. Note number 2, my lord. The case of Marto Kambo and 6 others of AP in his judgment and order dated 39/2024 in session has already been processed in another E5 court. Suitable advice of the lawyer based on the court judgment has not yet returned. However, as stated above, Sri Marto Kambo was appointed as a AE against the deputation vacancy of Sri Gumto Ette, who went on deputation to Hydropower Department and later absorbed his service in the department with effect from 27 to 2009, my lord. Means there were, my lord, vacancies, my lord, of the promotional quota. Hence, the clear-cut vacancy of AE occurred. And Marto Kamgo can be given national promotion from the date of the absorption of Sri Gumtoete under the Department of Hydropower as AE, my lord. The steps is being taken by the department, my lord, for reconsideration of my case, my lord. So, my lord, may I pray that, my lord, pendency of this writ appeal, my lord, the department is not barred to consider my case, my lord, in terms of the process initiated by them itself.
There is no pair for stay. There is no pair for stay.
My lord,
In judgment.
there is prayer, my lord. Major. Two prayers, my lord. Page 50, my lord. Prayer number 1. Stay suspend the operation and effect of judgment and order passed by Lagna Singular on such and such. And second prayer, my lord, further direction may be issued to respondent authority. The pendency of the extended appeal shall not bar to respondent authority to consider case of the appellant for
Is it necessary to state the operation of the judgment?
Well, in respect of the appellant, my lord, may state the judgment. You are admittedly, my lord.
Whether you have challenged this point in the writ petition?
No,
Regarding the next below rule, my lord. My lord, verbally it was submitted, my lord, orally submitted, a good my lord. That's why it was
It was
reflected,
not in your pleading also.
that's why it was reflected in the matter judgment, my lord. Anyway, admitted, my lord, it's a legal aspect, my lord, that can be always considered, my lord. Another aspect is, my lord, admittedly, my lord, a deceased name was recommended for promotion, my lord. Thereby, I tried to exhaust the, my lord, vacancy of the promotional quota, my lord.
Heard Mr. R. Soikia, learned counsel for the appellant, and Mr. Deepanging for
5 to 24.
respondent number
5 to 20.
5 to 24.
Just a moment, my lord. The number, let's see, 5 to 22 here. My lordships are not proposing to pass any interim order. Otherwise, I may be hurt.
You have any submission?
If your lordship is not proposing to pass any interim order, no, I am not making any submissions today. Otherwise, it's a whole new case that is being argued before the appeal. This is not the case before the
Yes,
learnership.
for rest of the respondents,
They,
Mr. Parme for respondent number
2 and 4, my.
2 and 4, and Madam
1 and 3.
1 and 3.
indeed, will may pray that when I'm pray that, my lord, the second portion of the entry prayer may be, my lord.
Second person.
The second interim prayer, my lord, that may be considered by a lordship. Tendency of the retribution not bar.
Oh, that can be,
Uh,
that can be.
No, my lord, cannot be, my lord, at this.
Why?
Because they already started the processing, my lord. No ground there, my lord.
Yes, what is your objection?
The they will give them a handle to might not give retrospective promotion, which is might not is now settled. That they are just because there was a vacancy, assuming there is a vacancy. There's no question of retrospective promotion in view of the settled position of the law, madam. Recent judgment, madam, where is the question of retrospective promotion? And this was a case, a totally new case is being argued before lordships. The case of the writ petitioners, they were together, the other writ petitioners and this appellant. Their case before the learned single judge was there. They were appointed, given officiating promotion against existing vacancies. That is why they are entitled to retrospective promotion. Even that argument cannot be entertained, my lord, in view of the recent judgments of the Honorable Supreme Court. And that fact is incorrect. That the learned single judge, a categorical finding that that fact is incorrect. As on 2012, there were, my lord, 17 extra promotions already made. There were 23 vacancies. So in 2011, a recruitment process was started. Since there were already 17 excess promotion being made, that 17 was given to us from the 23 plus 3 was given to them. Now that 3 was in 2012 along with the 8 additional posts filled up. Now if by learned, the appellant is aggrieved with the 2012 DPC, that was not challenged before the learned single judge. That DPC will have to be challenged, saying that Bingayate was junior and Purpa Wangyal was junior, and he ought to have been considered. There is another aspect, delay and all these things are there. That was not even under challenge. How can that be considered? Now, if your lordship makes an observation, just a moment, I have not finished. If your lordship makes an observation now that retrospective promotion may be should not be a bar, they would give the handle to the minor responsible authorities to minor consider it, which would be against the law, minor. Let notice go, minor. We'll argue with minor. Sort that any day, minor. I am ready. Because
if that is the argument, my lord, advanced by my learned friend, that this, my lord, portion of the judgment was not put to challenge by the respondents also, my lord.
this is the mere observation, minor. There is a categorical finding that there were no vacancies.
This observation, the respondent noted
Accordance with law.
yes, they have acted upon therefore, my lord.
That is subject to challenge, my lord. It is accordance with law. Yeah, after Union Manpreet Singh Poonam and my lord, the latest judgment, my lord, in Union of India and my lord, just a moment. Bihar is an electricity board. It's a question of retrospective promotion. We settle law now. I can furnish, my lord, if your lordship. Say where. Recent judgment, 2024.
This intercourt appeal is directed against the judgment. An order dated 31/8/2024 passed by the learned single judge in WPC number 49 of 2023. Or is the memo by the announcements of there, and also peruse the judgment. An order dated 31/8/2023 in WPC number 149 of 2023. Let notice be so to the respondents, returnable in 2 weeks.
My lord, I'm any day, my lord.
Well, that, my lord, already, my lord, the process has been initiated by the department. That may be continued, shall not be barred, my lord.
Why should your lordships observe that, man? There is already there. They are considering it. Why should that come from your lordship, sir?
Because of the writ petition filed by the, my lord, the promotees who were promoted on against the direct recruitment quota, tendency of the writ appeal, my lord, of that, my lord, writ appeal, the process has been stopped, my lord.
Okay, we will fix a very short time.
Yes.
We will hear. What is the
That observation,
24, nobody is appealing.
23, 24?
I'm appealing for everybody, my lord. But they have, my lord, just corrected it. I'm not very sure how the.
No, but just few minutes back, you have submitted only 22, up to 22.
Here, my lord, they have corrected. I can make out. I'm appearing for all the 20 private respondents.
For all the respondents.
Yes. Looks like 22 too.
So, returnable on suggested that then.
But I'm ready anyway.
The first, First week of January, my lord.
First week of January. Suggest like that.
It is on on 9th, my lord.
Ninth.
9th.
No formal notice is required to be issued since all the respondents are represented by them in this council. All for the record. This recording.
All right. May it please your lordships.
Yes.
My lord, this is a public interest litigation regarding, my lord, the construction of National Highway, this package B from Naharlagan to Nirjuli.
Yes.
Around 500 crores were sanctioned, 495 crores. It envisages a flyover, map that has 149 pillars. And, my lord, service roads. And it was to be completed on 7th of this month. My lord has seen what is happening. Despite directions of your lordship, my lord, my lord Nair will recall. On the first day, there was a direction from the Honorable Court that they should make it motorable. I will admit, my lord, they did something, my lord. Now they did
Service roads.
Yes. And on the last occasion, the lordship will kindly peruse the last order, my lord. I am not here for changing the contract or anything, my lord. I am only
Expedite the work.
my lord.
To expedite the work.
Yes, my lord, they were supposed to finish on 7th of this month, my lord. They have done nothing. On out of 149 pillars, my lord, your lordship, take this road every day. 11, my lord, pillars, they have also not been completed. Only the roads have been fixed. They are doing nothing. They are not coming up with anything. Why that has been, they have not done anything. 7th of December, my lord, 2024. It is in their affidavit. And, my lord, on the last occasion, the submission was made that they gave termination notice. Thereafter, the contractors have assured that they are going to start work and the service roads will be completed. Nothing has been done. Nothing has been done, my lord. It does not absolve the government. The government cannot say it is the contractor's fault because their agreement itself, my lord, envisages that if the contractor fails in their duty, it is incumbent upon the department, my lord, to execute the work and, my lord, this is the condition, my lord.
Yes. Who are for the respondent?
They are supposed to, my lord, file this.
In fact, today's
Present
status,
status report also, I don't know, I have not been for this.
I'll give you.
They have.
Status
No,
report is on 30/11.
Pass through that road every day, my lord. Your lordship passes through this road every day, my lord. What is that?
My lord, the status report, my lord,
Why
of
don't
course,
you do something about it?
because it has
Yeah.
been given.
Is this your status report?
Yes, we have, we'll file it if required by way of an affidavit also, my lord. My lord, of course, if my lord comes
Even
to,
now, just a moment, even now, my lord, if works start in right, my lord, at least the citizens of this, all we want is a road, my lord. Even if they now start in right, even that they are not doing, my lord.
my lord,
There's no men and machinery, my lord, on site.
my lord, of course, the deadline for completion was on 7th of December.
Seven?
This 7th.
3 days,
However,
over 3
yes,
days,
ma'am.
3 days left.
only 3 days. That has become impossible, in fact. And in fact, the road as well as the flyover was subcontracted to one TK Engineering. Now, the flyover couldn't start, because of which the road also couldn't be developed. Now, if my lord sees at page 4, of course, it's very unsatisfying, my lord. The cumulative physical progress and financial progress up to 30/11/2024 stands at 35.7% only, my lord, and 31, my lord. Now, the subcontractor, my lord, TK Engineering, has been terminated, my lord, from the flyover portion. And then for the flyover, a new contractor has been brought in, my lord. They will, the expert, which as per them, they have been directed to mobilize the men and machinery and start the flyovers. The TK Engineering will now be only with the road portion, my lord. Of course, my lord, at least because of this PIL, something has started, my lord, and now the contractors are also,
But when you are going to complete the same?
my lord,
Something
now,
that started, that's fine.
yes, my lord. Oh, when, my lord, I'll seek some more time so that when this new contractor for the flyover comes in, and at least they should give an assurance, the bar chart, what will be their completion, my lord, date, and what will be the progress per month, my lord. That at least first let them give a bar chart, my lord, if this new
Something,
contract.
my lord, I am not understanding because the work was awarded to Uthil Shivam. That's the main contractor.
Yes, my lord.
He entered into a subcontract with TK Engineering. So what happened to Uthil Shivam? Then who is supposed to construct the flyover? So what is Uthil Shivam doing? He is the main contractor. He sublet it to 49% of the work. From what I am hearing from the learned additional advocate general, it appears he sublet the flyover part to TK Engineering. Am I correct?
Yes.
Now, what will Uthil Shivam do then? My lord. Uthil Shivam, Mr. Dubey, I believe, also online.
Yes, Mr. Dubey?
Wait, please, lordships. Lord, I appear on behalf of the respondent number 7, Lord, who is the main contractor. Lord, as my learned friend has stated, Lord, what has happened, respondent number 8, we had engaged earlier, Lord, for the work. Lord, now this subcontract, so far as part of the work has been, Lord, terminated. And, Lord, we have engaged a new set of, Lord, contract, Lord. So we'll be requiring some time, Lord, as regard the progress of the work by submitting the by chart and all, Lord. Because the entire thing was not in our hand because of our, Lord, subcontract work, Lord. This fact, Lord, that the progress has not been satisfactory.
So you are for the respondent number 7. Mr.
Yes,
Dubey,
my
you
lord,
are
I am
for
for
respondent
respondent
number
number
7.
Yes, my lord, I am for respondent number 7.
So you have, Mr. Panging, you have gone through this report?
No, I have not received.
I'll be submitting. Only
I don't need to look at this, my lord. I see it every.
of course, my lord.
No.
I have understood. I have understood. I
It
will
is
take a
stated
copy.
that this physical progress is 35.74% and financial progress is 31.36%.
As far as the Naharlagan town section is concerned, that is an absolute, I don't want to say the word, absolutely incorrect. How can it be 31%? There are supposed to be at least 149 pillars. That's only the pillars that will hold up the structure, superstructure.
Then
The pillars are not there.
we will appoint commissioner
Yes,
to inspect the matter.
Yes.
Inspect the situation. He will go to
yes,
the
yes,
back and
absolutely, my lord.
submit
Because
the report.
not only that, my lord, even it's up to Nirjuli, my lord. That part they have constructed the fold end, my lord. It is broken down completely. Nothing is there. It's unbelievable, man. We all know what has happened, but I can't say it in court.
So suggest the name of the advocate who can be appointed as commissioner.
Yeah, learned senior counsel, Mr. A. Apang.
Yeah.
Yeah.
Is he regular in the court?
I don't know if he's keeping well also or not.
He was, he had,
He may not be, he may not be.
I don't see.
I don't, only one commissioner?
Two or three will be better.
Yes, one of them can be Miss Dungan.
Commission.
And one is Mr. Apang and other
One more.
but Mr. Panging, can you obtain consent from him whether he is interested or not?
Yes,
Because if he is not interested, then
yes. Can I give the names later on?
later on, yes.
Might not be passed out or give the names.
Okay. Third, Mr. D. Panging, learned counsel for the petitioner. And Mr. N. Roton, learned standing counsel for the respondent number.
I'm for, 1 to 5, my lord.
1 to 5. And Mr.
Uh,
Soikia,
Oh,
Highway, my lord, 4, 1, 2. 1, 2, and 3, my lord.
1, 2, and 3.
Mr.
And
Mr. Soikia.
Soikia for respondent number
4 and 5.
4 and 5.
4 and 5.
4 and 5. And Mr. Dubey for respondent number 7.
7.
7.
6. Who is for 6?
I'm appearing on behalf of MTA
Union of India.
for respondent number 6.
Respondent number.
Respondent.
Your good name, please.
Ensure.
Person to order dated 11/11/2024. Mr. Roton, learned standing counsel for the respondent number so and so has submitted one status report before. this
Additional
court.
AG, ma'am. Additional.
Additional advocate general. So status report before this court. Prepared by Executive Engineer, Naharlagan Highway Division, PWD, New Zealand, dated 23rd 11/2024. We have perused the status report, which indicates that the cumulative physical progress and financial progress up to 38/11/2024 stands at 35.74% and 31.36% respectively. But Mr. Pangeng, learned counsel for the petitioner, submits that he is not at all satisfied with the progress report so furnished by Mr. Roton, learned additional advocate general. In view of the submission of learned advocates of both the parties, we deem it appropriate to appoint a commission to inspect the site and to furnish a detailed report before this court. Honor,
My lord, can it be?
when 15 days time?
Yes, yes.
15 days time. Honor before next. Nineteen. 19. Mr. Roton, learned additional advocate general shall also furnish a status report on that day, indicating the progress to be achieved from today till 19, 18.
Well,
Place the matter on 18.
My lord, can it be then 23 so that at least some substantial progress?
This is last day.
Oh, yes.
You place-
I will suggest.
Obligement.
Oh, we will issue notice. Heard, Mr.
Keda.
Learned counsel for the applicant, stroke appellant. This application under section 5 of the Indian Limitation Act 1965 is preferred by the applicant for condonation of delay of 5 days in preferring appeal against the judgment and order dated 26/9/2024, passed by the learned special judge Pokso Kam District and Session Judge UPA Papumpare District in Pokso case number 02 of 2023 under section 109 212 292 within bracket small a 323 354A 354B 376 within bracket AB 376 within bracket 3 376 C 511 506 IPC read with section 6 10 12 14 1 and 2 17 21 within bracket subsection 1 21 2 and POXO of POXO read with section 66E and 67 of the IT Act. Let notice be issued to the respondents returnable in for weeks.
Yes, for.
For which to step be taken by registered post with AD.
No, as per this latest notification, it should be through PP. As per notification.
This,
Yes,
yes.
through PP and police.
Ah,
concerned police.
yes. Respondent number 3 to 20 3 to 25. Step be taken by not necessary. Step be taken through the office of the public prosecutor. State of ownership orders. However, no formal notice is required to be issued to the respondent number 1 and 2. Since Mr. Ite.
Your lordship,
That is not
your lordship, here
CPS and receive notice.
SIT is also there, your lordship. They have their own special PP, your lordship, SIT.
You
There's
are
one
not
number 2.
representing 2.
I am 1, your
respondent
lordship. For appearing for 1. 2, your lordship, I am not authorized, your lordship.
not authorized.
Special PP
Who
is
is, who
there.
is for
2 is J Sring, your lordship. J Sring is for SIT.
is he present today?
No, not present, perhaps, your lordship.
Okay, notice be issued to the respondent number 3. However, extra requisite copy of the petition may furnish to Mr. Ite during the course of the day. List the matter after 4 weeks.
Yes, your lordship. Your lordship, the name SIT may be reflected in the cause list, your lordship. Since it's SIT, we have not authorized, your lordship.
This shall reflect the name of standing council or
Yes, special PP, SIT.
special PT
Yes, your lordship. Yes,
in the cause list.
yes, your lordship. Deeply obliged.
May I please, your lordship, being aggrieved by the issuance of land possession certificate, wherein the petitioner has filed his PIL
So, and apart from that, this petitioner has filed several complaints and in regard to the issuance of NOC and all. So most relevant portion, your lordship, is I have annexed the grievances which they have sought. Is at the main PIL petition also at page 287. Annexure 8. Pursuant to complaint filed by the present petitioner, your lordship. Inquiry was initiated, but this aforesaid inquiry report was neither furnished nor submitted. So accordingly, your lordship, the main grievances has been in pursuance of this complaint. Now, the state has submitted their inquiry report, your lordship, but this honorable court has also directed to furnish the inquiry report and file affidavit. Accordingly, they have filed, which is also at, they have filed one additional affidavit. That is their inquiry report. Is that page annexure 1 series. So basic grievances of the present petitioner has been addressed. So therefore, in view of this inquiry report submitted by the chief respondent, I have filed one this interlocutory application for closure of this PIL and a liberty may be granted to challenge this inquiry. That is the basic prerogative. Subject to your lordships.
My lord, if our affidavit, my lord, dated 3/6/2024, where the inquiry report is there.
No, instead of filing a separate writ petition challenging the inquiry report, you can challenge it in this PIL also.
While
Let the PIL remain. You can file additional affidavit challenging this PIL. No, sorry, challenging this inquiry report.
should they, in that case, Lordship, that may be reflected in the order, Lordship,
Hmm.
that I may be allowed. If such is-
In fact, we have raised preliminary objection regarding the maintainability of this PIL also, my lord. Basically, he is seeking for the cancellation of all the LPCs issued to private individuals, my lord. Those persons will be affected by this honorable court's order. They have not been made party, man.
Basically, Your Lordship, the LPC which has been issued is completely comes under the reserve forest area. In pursuance, there are notifications are there, Your Lordship.
As per the inquiry report, my lord, there is no this lapse on the part of the authorities. Twenty-one 3/2024 order.
Mr. Singh, this IA, you withdraw it. This IA, we did not. But Mr. IA, but Mr. A.K. Singh, council board commissioner, and also Mr. N. Batum, London edition, DG, appearing for the respondent. Mr. Singh on instruction submit that he is not pressing the IA. IA stands closed. Mr. Singh.
Lordship, since I have been instructed to file this interlocutory application, Lordship, I am, insofar as the withdrawal part is concerned, I have not pressed, that may be, this matter may be listed tomorrow. I will take the instruction and then. It was filed. Tomorrow, for tomorrow.
We'll not consider this IA. We'll keep it separate.
Lordship, that may be dismissed.
During the course of the hearing, Mr. But if you want to Mr. During the Mr. Singh on the during his submission has submitted that the connected PI is being sought to be so withdrawn with a view to institute a fresh proceeding assailing the inquiry report brought on record by the respondents by way of filing an affidavit, an additional affidavit dated 3/6/2024. So, on considering the said submission, we are of the considered view that for the purpose of bringing on record materials to counter the contentions raised in the said inquiry report, withdrawal of the PI would not be called for, and the petitioner would be at liberty to bring on record pleadings in the PIL itself to assay the findings in the inquiry report. So, in that view of the matter, the interlocutory application number 239/2024 stands closed. Also, PIL 13/2023. So, in view of the Mr. Singh, learned counsel appearing for the petitioner submits that he be given 3 weeks time to file his response, but to bring on record pleadings assailing the findings arrived at by the Chief Conservator of Forest, Eastern Arunachal Circle, Teju, Arunachal Pradesh, in his inquiry report dated 9/3/2023, brought on record in the present PIL by the respondents by way of filing an additional affidavit dated 3/6/2024. We have, the said prayer is not objected to by Mr. N. Batum, Learned Additional Advocate General, so in view of the above, we grant 3 weeks time to the learned counsel for the petitioner to bring on record pleadings assailing the findings contained in the said inquiry report dated 9/3/2023. Raised it to list these matters after 3 weeks on a date to be fixed.
Okay.
Mato Kato.
Yes.
Can it be list day after tomorrow, my lord?
10th of
Day after tomorrow. Fifth.
day after tomorrow.
Yes, my lord.
Okay. On the appear being made by Mr.
And Sora.
Learned Counsel appearing on behalf of Mr. M. Kato, Learned Counsel to the respondent, rescission is the matter of day after tomorrow.
Yes, my lord.
Okay.
Okay. And my lord, one more item number, my lord, 4, on behalf of M. Kato, my lord.
Same order. Okay.
Lordship, there is an interim order. Let me be continued.
Four.
Yes, item 4. I am for the
Interim
petition.
order. As earlier shall continue.
And my lord,
Yes.
in item number 7, 8, 9, and 24, my lord. Take consent from the petitioner, my lord. On behalf of M. Kato, my lord.
In this case, I am appearing for a petition. If not inconvenient, my lord, can it be taken up tomorrow, my lord?
Yes,
Can be taken up tomorrow, my lord, tomorrow.
Yes, my lord.
But,
tomorrow.
Yes, my lord.
All these matters.
Yes.
so a single hearing will do, my lord.
Okay.
7, 8, 9, and 24.
Okay. Tomorrow.
Deeply obliged.
The interim order passed earlier may continue.
In which item interim order is?
In item number 9, my lord, order dated 24/7/24,
Item number 9.
item number 9.
Okay. Interim order first earlier shall continue. Okay. Yes.
Deeply obliged.
May I please, Your Lordship? Your Lordship, I like to mention item number 14 and 15, Your Lordship. Your Lordship, similar matter is fixed tomorrow, Your Lordship. Can it be fixed on tomorrow, Your Lordship?
Your good name?
E. Menjo, Your Lordship.
You are appearing on behalf of?
In 14, respondent, Your Lordship, and 15, petitioner, Your Lordship.
The appear being made by Mr. Your good name?
E. Menjo, Your Lordship.
You are appearing on behalf of?
Petitioner, Your Lordship, in item number 15.
No, your name is not there.
In 15, Your Lordship, my name is there, Your Lordship.
Acha, okay. Petition learned counsel for the petitioner with consent from the other side.
I am for the respondent number 6 and my lord, I filed the IA for my vacation modification of the entry order, madam. And my friend is submitting that the read petitioner is fixed on for tomorrow, madam. So the entire matter can be heard together, madam.
Yes, Your Lordship.
Tomorrow?
Yes, Your Lordship.
Okay.
Similar matter is fixed
Tomorrow.
tomorrow.
Madam, Can it be on admission hearing, madam?
Okay.
And madam, kindly
So
observe.
service completed.
Your Lordship, I'm filing rejoinder today, Your Lordship.
Okay.
Your Lordship.
Tomorrow we can fix it.
Yes, Your Lordship. Sure.
Tomorrow.
Madam, in admission column, my lord.
Okay.
And madam, kindly observe one, madam, the maintainability of the read petition shall be also heard together, madam.
Pardon?
Maintainability of the read petition, madam, shall be also considered.
No, you can raise the issue tomorrow at the time of hearing. Is it necessary to record it today?
Madam.
Lordship, one more, Your Lordship. Item number 16 and 17, Your Lordship.
Yes.
Your Lordship, can it be fixed on 5th of December, Your Lordship? Day after tomorrow, Your Lordship.
That's right for by Mr. Swenson.
Oh, sorry, Your Lordship, 17 and 18.
You are for here in item number 16, you are for respondent.
Yes, Your Lordship. No, Your Lordship. For petitioner, on behalf of Your Lordship, Pita for Your Lordship.
Peter for.
Your Lordship.
Rescission is the matter day after tomorrow.
Yes, Your Lordship. 17 and 18, Your Lordship. 18 also, Your Lordship. Same. Much obliged, Your Lordship.
May I, Lordship?
Yes.
Lordship, I like to mention one pending matter.
This may be listed on 5th of this day after tomorrow. Much obliged.
Your Lordship, if I may mention item number 16, we have received instructions from the client to withdraw the matter.
16.
Yes, 16,
Somebody has already mentioned the method.
17 and 18.
Not 16. Your good name?
Ironia, Pandit Ronya.
Mr. Pandit Rania, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. It is accordingly allowed. This WPC stands for disposal. WPC number so and so stands for disposal of withdrawal. Yes.
I would like to mention item number 12 and 13.
Item number
12 and 13. Both are connected. I am appealing for the respondent number 1 and 2.
one.
Pleadings have been completed, madam. Matter may be listed for
Your
admission
petitioner.
hearing.
Yes, Your Lordship, there is an urgency in this matter, Your Lordship. So this matter may be listed on 10th of
10th.
this month.
10th.
Yes, madam.
At the admission.
As
process.
agreed by learned advocates of both sides, SSL is the matter on 10th of December in admission column.
Yes, Your Lordship.
Yes.
There's an interim order, it may be continued.
Interim order.
Yes, sir.
Interim order passed earlier in which matter?
In
12.
RE petition number 103, Your Lordship.
In IA, my lord.
I 7124.
Your Lordship, interim was granted in 103/2024.
103. Okay, interim order in passed in WBC number 103 of 2024 shall continue. Okay.
Hello.
Obliged, madam.
My lord may recall that yesterday when I was making my submission. I'm sorry.
Yes.
My lord may recall that yesterday, my lord, when I was making my submission, some reference was made to a cabinet resolution, cabinet decision. And it was pointed out that since I'm not challenging the very cabinet decision, well, the role of AG to that extent is limited. Now, my lord, I will place that very particular cabinet decision and I will explain the reason as to why the same right now is not being challenged. But anyway, my lord, there are certain facets to that very particular cabinet decision, which, my lord, I would certainly address before the lordship. Now, the cabinet decision, my lord, which was being referred to, my lord will find at page 93 of the writ petition, annexure P17. In fact, my lord, this very cabinet decision is under challenge in this writ petition. But there was a reason as to why I did not address my lord on the challenge aspect. '93, my lord, is the forwarding letter. The relevant portion, my lord, will find at page 94, the cabinet note. The cabinet note, my lord, the heading is very relevant. The heading pertains to unclassed state forest, that is USF.
No, 94.
My lord, it's writ petition, 242.
Yes.
94. Now, my lord will see cabinet note regarding unclassed state forest. So the topic is USF. It is in connection with the USF. The decision of the cabinet I read, after detailed deliberations, the cabinet inter alia noted the following observations made by such and such, learned senior additional advocate general, that quote, the indigenous tribals of Arunachal Pradesh has inalienable land rights, being the landowners, and has rights over the resources. The community and private land rights has been recognized by ancestors through customary practice, has been passed over to the next generation till today, unquote, and accepted the recommendation of the committee that, quote, the land compensation is must for acquisition of land termed as a Jhum land in local language and extinguishment of rights in USF area, unquote. So the important part is this very particular sentence, quote unquote, the land compensation is must for acquisition of land termed as Jhum land in local language and extinguishment of right in USF area. Now, my lord, the and over here, whether it is disjunctive or conjunctive, my lord, my submission would be, it has to be disjunctive, it cannot be read as conjunctive. And because either may not we proceed on a premise that a Jhum land has to be necessarily a USF only. If Jhum land is necessarily USF, then the two aspects come in. Number one, extinguishment of rights over the USF, and number two, the Jhum land per se. So if the Jhum land is acquired, yes, you are entitled to the compensation, but at the same time, you are entitled to be compensated for extinguishment of your rights in the USF area, which is the Jhum land itself. Possibly this is what they intend to say. Now, my lord, I would come to this. What would it lead to? Now, next. As regarding the rates for payment of acquisition of such kind of land, the cabinet decided that in view of different geographical regions in the state and land having different economic potential in various areas, the respective deputy commissioner, land acquisition collector may fix the rates as per prescribed legal provisions and guidelines issued by the government from time to time. The cabinet also approved the proposal that in case the villagers agree, then the land can be acquired at rates less than the published rates of respective districts. And in case the villagers of a particular area do not agree with the published rate of concerned district on the ground that the actual land rates are quite high, and user agency insists on acquisition of that particular piece of land only, then a board consisting of government officials and representatives of user agency can be formed by concerned DC to assess the rates of that particular piece, stroke parcel of land, and the recommendations of the board be submitted to the government for approval. The cabinet also approved the recommendations of the committee that the necessary charges to forest department shall be payable for diversion of forest to non-forest purpose, and the compensation assessed by the land acquisition collector be treated as composite compensation for diversion of forest area for non-forest purpose, and compensation to the community stroke individuals for extinguishment of their rights over the land. In terms of this cabinet decision, the circular dated 1st June 2018 was issued. The relevant portion of the circular, the second paragraph, lordship may see. As regarding the rates for payment of acquisition of such kind of land, the cabinet decided that in view of different geographical regions, the state and land having different economic potential in various areas, the respective DC land acquisition collector may fix the rates as per prescribed legal provision and guidelines issued by the government from time to time. Language is similar to cabinet decision. Then the last paragraph, the cabinet also approved the recommendations of the committee that the necessary charges to forest department shall be payable for diversion of forest to non-forest purpose. This is important. Diversion of forest to non-forest purpose, and the compensation assessed by the land acquisition collector be treated as composite compensation for diversion of forest area for non-forest purpose, and compensation to the community stroke individuals for extinguishment of their rights over the land. Now, I'm not pausing here. I did not really address your lordship on the challenge to this very cabinet decision simply because, from the evidence and prima facie from the materials available on record, I find that even though the land in question was acquired under Regulation 10 of the Jhum Land Regulation of 1947, as per the averments of the private respondents themselves, the cultivation is a permanent cultivation, number one. The land is a plain land. It's not even a terraced So therefore, my lord, the jhum is not really a jhum land. Ultimately, my lord, who knows about the land more than the person who owns the land? When the landowner himself says that my land is not a jhum land, then the matter should end there. That is one part of the matter. So, my lord, it is not a jhum land, number one. Number two, assuming for a moment it is USF, can we call it USF either? Had it been USF, last 4 to 5 years, they would not have sit tight and did nothing, because they did nothing in the last 5 years for seeking approval of the government of India for diversion of this land for non-forest purpose. It's a forest land. If it is a forest land, it needs to be diverted for the non-forest purpose. And for that purpose, under Section 10 of the Forest Conservation Act 1980, in principle, approval of the government of India is necessary. Number one, there was no proposal from the government of Arunachal Pradesh to the government of India. Number two, therefore, there was no in principle approval under Section 2. Since none of the things have happened, therefore, my lord, I'll proceed on a premise. Number one, it is not USF. And number two, since the landowners themselves say it's a permanent cultivation, it does not even fulfill the definition and the basic ingredient of the jhum land. So, and they got the compensation under the 2013 Act. It is their land. That's so far so good. Now, can they be given extra? On this, your lordship may see now the second aspect. My lord may turn to Section 107 of the 2013 Act. Though, my lord, 2013 Act is a central legislation, but my lord will take note of Section 107, what it mandates. Power of state legislature to enact any law more beneficial to affected families. It reads, nothing in this act, it begins with the non-obstant clause. Nothing in this act shall prevent any state from enacting any law to enhance or add to the entitlements enumerated under this act, which confers higher compensation than payable under this act, or to make provisions for rehabilitation and resettlement, which is more beneficial than provided under this act. So nothing in this act shall prevent any state from enacting any law. And it's a power of, the heading is power of state legislature to enact any law. So, my lord, by way of this central legislation under Section 107, the state legislature has been given the competence to enact a law if the state in question desires higher compensation for its people because of various reasons. Now, my lord, had this been so, instead of this cabinet resolution, they ought to have enacted a law in terms of Section 107. By way of a cabinet resolution or by way of a cabinet decision, you can't exercise power under Section 107. 107 is, the law has to be enacted by the state legislature. This power has been delegated. The state legislature could have enacted a law under 107. Instead of the law exercising power under Section 107 of 2013 Act, they took a cabinet decision. That's not my first part of my submission. Now, my lord, secondly, my lord is familiar with the settled legal principle that if a law mandates to do something in a particular manner, it ought to have been done in that manner or not at all. 2013 Act mandates under Section 107 that if you want to give enhanced compensation, if you want to provide for something more other than what is provided under this very 2013 Act, enact a law under 107. State legislation has been given a power. You do not exercise power in this way. You exercise power the other way. The principle comes in, my lord, when a statute provides. I beg your pardon?
Nazir Ahmed principle. Nazir Ahmed principle.
I couldn't.
The principle laid down in the case of
Oh,
Nazir.
it is, my lord. In fact, since the days of Privy Council, lordship, my lord would recall Taylor versus Taylor, the earliest decision to till date. This principle is being reiterated time and again. The last time I saw it was in 2023 10 SCC. The same principle referring to Taylor versus Taylor. When a statute provides for doing a thing in a particular manner, it should be done in that manner or not at all. 2023 10 SCC, the relevant paragraph below, para 28, they reiterated their principle of law. 2023 10 SCC 232. Practically, from Taylor versus Taylor, there is a corpus of law on the subject. Series of pronouncements. My lord will find in para 28, they have given all the citations beginning from Taylor versus Taylor 1875, followed by Rao Shiv Bahadur Singh versus the state of Andhra Pradesh 54 1 SCC. Lordship will see this. Lordship will take my copy. It's there. Para 28. The time-tested principle they refer to. They give a notation 10, and under 10 they refer to all the cases.
Yes.
Now, my lord, thirdly, now, my lord, I am anticipating what may come from the other side. Assuming for a moment, my lord, their counter argument is advanced that executive power is coterminous to legislative power. It's another principle. Article 162 says so. If there is a legislative power vested in a state, then the executive power of a state is a legislative power. A cabinet decision is an exercise of executive power under Article 162. Assuming if this is argued, whether this argument would be sustainable. Now I turn to Article 162. Now I'm not assuming if they argue this. Lordship will see Article 162. No, my lord, I will reserve many things for the reply because ultimately none of this has been argued till now.
Yes.
162, subject to the provisions of this constitution, the executive power of a state shall extend to the matters with respect to which the legislature of the state has power to make laws. So, my lord, assuming for a moment they argue, well, we have the power to make a law under section 107, our executive power extends to that, is coterminous to that legislative power. For some reason, we could not enact a law, we will do it. But right now, we have exercised the executive power under 162. Will it be sustainable? The reasons are two, it will not be sustainable. Reason number one, Lordship will see proviso. Provided that in any matter with respect to which the legislature of a state and parliament, any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subjected to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. So, my lord, 2013 Act has already come. Section 107 mandates, if you want to provide for some enhanced compensation other than what is there in 2013 Act, do it by an act of state legislature. Their power is curtailed. It is subject to section 107. They can't just exercise power under 162. Now, finally, my lord, there is yet another facet to it. Can we really call this cabinet decision a decision in exercise of executive power under 162? The answer would be no again. Lordship would see the manner in which decision is taken. Is it expressed in the name of the governor? This is one of the basic fundamental, my lord, of any exercise of executive power. It is to be expressed on the name of the governor. Was it placed before the governor? Nothing was done. So, my lord, my submissions are like this. Number one, the cabinet decision in the present case has no relevance because the land in question is not a Jhum land, it is not a USF land. So I am not required to challenge the cabinet decision. Assuming for a moment if it is held, no, it is a Jhum land, no, it is a USF land, though it is not, because there is no in principle approval, no clearance of the Government of India under Section 2 of the Forest Conservation Act. Even in that case, my lord, this cabinet decision is no decision in the eye of law. Number one, it is contrary to the very mandate and scheme of Section 107 of the 2013 Act. Number two, the cabinet decision would not apply in view of the proviso to Article 162 in respect of the power to be exercised under Section 107. And thirdly, this decision is not expressed in the name of the governor, and the proper formality under Article 166, the rules of executive business, having not been followed, it cannot be called an exercise of power under Article 162. My lord, I will place case laws on these aspects, provided this argument is advanced. But the moment my lord comes to the conclusion that this land is not a Jhum land, it is not a USF land, it's a private land for which they have been compensated under the 2013 Act, the matter ends there. My lord may not even look into the challenge of the cabinet decision. And in any case, my lord, the final argument will come. Power by way of cabinet decision simply cannot be exercised because when Section 107 clearly mandates for doing of a thing in a particular manner, it has to be done in that manner or not at all. The principle will come in. So these are the four reasons for which, my lord, the cabinet decision would not come on the way. Now, my lord, there is, my lord, another aspect to the case. But again, my lord, now I have to assume, because I don't know whether they will argue this point or not. They may, my lord, additionally refer to Section 105 of the 2013 Act. I'm assuming now, I can't help it. Just a minute, my lord, I'll... My lord, may have a look at Section 105 now. Yes. 105.
105.
Yes, just a minute. My lord, it is 103. I'm sorry. I made a mistake. Section 103. Provisions to be in addition to existing laws. 103. The provisions of this Act shall be in addition to and not in derogation of any other law for the time being in force. They may argue, they may say that RNR policy 2008 is very much there. It is an existing law. The land is a Jhum land. It's USF. So RNR policy 2008 has to be read in conjunction with, in harmony with 2013 Act. Because Section 103 says so. Assuming for a moment, provision of this Act shall be in addition to and not in derogation of any other law. Law, they may say, is a law within the meaning of Article 30. To that extent, my lord, even the RNR policy 2008, which was published in the Gazette, is a law within the meaning of Article 30. So they may say it has to be read in harmony with 2013 Act. I assume, I don't know. Now, my lord, I'm testing this argument also, provided they argue this. Now, my lord, whether 103 has any relevance, for this we have to go into the statement of object and reasons of 2013 Act. Here, Lordship may see para 22, statement of object and reasons.
Yes.
Para 22, my lord, reads, certain sensual acts dealing with the land acquisition have been enlisted in the bill, because when the bill was placed, the statement of objects and reasons said that, have been enlisted in the bill. The provisions of the bill, and here the language is important. This language is borrowed there in 103. The provisions of the bill are in addition to and not in derogation of these acts. The provisions of this act can be applied to these existing enactments by a notification of the central government. Now, my lord, will see section 105, subsection 3. These three things have to be read together to understand the scope of section 103.
Yes.
The central government, section 105, subsection 3, the central government shall by notification within 1 year from the date of commencement of this act direct that any of the provisions of this act relating to the determination of compensation in accordance with the first schedule and rehabilitation and resettlement is specified in the second and third schedule being beneficial to the affected families shall apply to the cases of land acquisition under the enactments specified in the fourth schedule, or shall apply with such exceptions or modifications that do not reduce the compensation or dilute the provisions of this act relating to compensation or rehabilitation and resettlement as may be specified in the notification as the case may be. Lordship may see the fourth schedule. There are legislations enumerated therein. So, Lord, it is in connection with that. 103 says so. Fourth schedule. Fourth would be at page 58, my lord. There are total 13 legislations. So, my lord, when section 103 says in addition to, this is what it is. There are 13 legislations and National Highways Act is also there. As serial number 7, Lordship will find National Highways Act. So, in addition to means this. There are case laws on the subject. In my reply, I will place all that if they argue this point. In the Mihin Laling case also, my lord, this was looked into, this aspect. I will place that, the division line. But anyway, my lord, let them argue this. But in any case, it's neither a Jhum land nor a USF land. So I'm not very serious about the challenge. So, my lord, I just sum up. There is nothing substantial. I'll sum up, my lord. There are 6-7 broad points. My first submission would be the land of private respondents is a private land as per the pleadings of the state and private respondents. Hence, 2013 Act applies. And Chapter 9 of the RNR Policy 2008 is not applicable. Chapter 9 of the RNR Policy 2008 has no application.
Yes.
Secondly, my lord, Chapter 9 of RNR Policy 2008, especially the scheme of Chapter 9 of RNR Policy 2008 is for compensating community for extinction of traditional rights to collect and use forest produce from USF. Firstly, it is not USF. Secondly, we are not dealing with community, we are dealing with individuals. Community and individuals are two different things. Community has been specifically defined both under the policy as well as under 1947 regulation, including the State Act. Thirdly, calculation sequence under 2013 Act is also not followed. First schedule to the 2013 Act must be adhered to. And errors in the award has to be corrected by following the right sequence. And fourthly, my lord, state has not followed the precedents. In the previous cases of Jhum land acquisition under 1947 regulation, both in the Injonu case, where NSPC itself will not the same project, everything same, they did not follow the RNR policy for assessment of compensation. In the Mihin Laling case also, they did not follow. So in the previous cases, it is for the first time that a state brought in RNR policy 2008 while making assessment under 2013 Act. Previous precedents not followed. A departure without any justifiable reason. Fifthly, my lord, the state can't approbate and they reprobate. Earlier, the state took a stand. In the Mihin Laling, the stand was even the solatium cannot be given if the land is acquired under the regulation 10 of the 1947 regulation. But the court conceded, court said 2013 Act to follow. The principle of compensation under 2013 Act will be followed. There was no whisper of RNR policy 2008. This was never a case of the state. And the state was represented then by Advocate General in charge. Dibang project, Injonu also, RNR policy 2008 was not brought in. So, state can't approbate and reprobate. In any case, my lord, since
Can that principle be applied here?
my lord, I would submit yes, why not? You are deviating one case, inconsistency in stand. You don't know what you are doing here. Because, my lord, cabinet decision was there even at that very point of time. That means you know what the truth is. You know this is not a Jhum land, these are all private lands. Maybe for some reason, you are not taking recourse to the acquisition proceeding under 2013 Act. For some good reason, you are acquiring land under Regulation 10. Since, my lord, compensation is being assessed under 2013 Act, nobody has a complaint. Because basically what they want is the money. So, my lord, the inconsistency. And, my lord, in any case, since, my lord, there is no proposal from the state government to the central government seeking the in-principle approval for diversion of so-called USF land for non-forest purpose, and consequently, there being no in-principle approval of central government under Section 2 of the Forest Conservation Act 1980, diverting this land for non-forest purpose, it has to be assumed. It is not a forest land. It is not USF. But finally, my lord, who knows about the child better than the mother? The owner says, my land is this. When owner says, my land is a plain land, on my land there is a permanent cultivation since time immemorial. On all he says so. We have to believe him. So substantially, my lord, these are the arguments. I do not know what will come from the other side. So, my lord, many of the case laws, provided they argue all this, I am not serious about the challenge because I personally believe I am not required to challenge the cabinet decision. So, my lord, I rest my case here. That's all, finally. And, I don't know, doctrine of waiver may not be argued because referring to this additional affidavit, earlier, my esteemed colleague, Mr. Chaudhary, was pointing out that very particular additional affidavit, they annexed that communication of scientists. So they said, look, you people never objected to it, so you waived your right. You conceded to application of RNR policy 2008. On that, my first argument is it has no application here. Because that communication of scientists is in respect of the main project, the people displaced from the project. It is for their settlement that this land is being acquired. So it has no application, number one. Number two, so far as waiver is concerned, my lord, one of the essential conditions of the waiver is there has to be intentional relinquishment of the right. We have not intentionally relinquished our right to apply such a principle over a private land. On intentional relinquishment, my lord, there are a series of judgments. Doctrine of waiver has no application when there is no intentional relinquishment of the right. If they are using such a communication for this purpose, we would argue there is no waiver. We have not intentionally relinquished our right. So far as different cases are concerned. The citation for this is 2022, volume 2 SEC on the concept of waiver. Para 16, 18 to 21. 2022. Volume 2 SEC, page 221. My lord may see para 16 first. Para 16 at page 233.
Yes.
Waiver is an intentional relinquishment of a known right. Waiver applies when a party knows the material facts and is cognizant of the legal rights in that matter, and yet for some consideration consciously abandons the existing legal right, advantage, benefit, claim or privilege. Waiver can be contractual or by express conduct in consideration of some compromise. However, a statutory right may also be waived by implied conduct, like by wanting to take a chance of a favorable decision. The fact that the other side has acted on it is sufficient consideration. My lord, we would submit. Para 16 squarely covers us. We have not intentional, there is no intentional relinquishment. Then para 18, 19, 20, 21, lordship may see those paragraphs. Principles have been discussed very lucidly. So our whole case is it is no application whatsoever. We are settling the displaced people in this land which we have acquired, which state has acquired for us. And it is part of the RNR rehabilitation and resettlement scheme under chapter 8 of the RNR policy. So it has no application whatsoever. So that's all, my lord. I rest my case here, subject to whatever may come from the other side. I will then further expand my argument. And in my reply, my lord, I will reserve certain things. And, my lord, if need be, going by the nature of case, because it has very serious consequences. If lordship comes to a different conclusion, then practically, my lord, floodgates will open. Even the Injonu people, their matter has already been settled and quietus has been given, then they will say, look, USF has RNR policy 2008, they're under 1,56,000 per hectare, 25% of the NPV. This was not given to us. Now you give us. We were illegally denied. And others also will come, my lord. In all other cases, everyone will come. Wherever, my lord, there is a acquisition of under regulation 10 of the Jhum land regulation. They would say apply RNR policy 2008. So, my lord, there would be no end to this. In any case, my lord, I'll give my written, my lord, arguments after everything gets concluded. Highly obliged.
Matter may be fixed on 5th, Your Lordship, 5th December. AG will be available on 5th, Your Lordship.
My lord, I'm sorry, only one thing, my lord. Next week, my lord, Tuesday I will be here, my lord. So whatever is there to be said in reply, I'll give my reply on Tuesday instead of Monday. Okay. It will be convenient because
Lord Executive Council assisted by Mr. Lord Head Council for the petition. And also heard by the person, Lord Head Council for state correspondence.
Lordship.
State correspondence. This is the matter of 5th of December for further deliberation.
Lordship, may I kindly fix this matter in the top of the list, Your Lordship.
And as top of the list.
Outline.
Yesterday's matter, my lord, instructions were sought from the senior government officer, my lord. Why I was not allowed to participate in the selection process, my lord.
Yes.
Mr. Tapin, we were supposed to take instruction, but he's coming.
Tapin.
Tapin, yes. The passover for the time being, madam.
Okay.
He's coming.
Okay. Next.
May I please, lordship? Is this petition has been filed for non-payment of the balance outstanding bills, my lord. My lord,
Balance
outstanding bills, my lord.
dues.
Dues, my lord. My lord, the person to an NIT dated 22/3/2022, my lord. The petitioner was accepted as a L1, my lord, and acceptance letter was issued to me, and everything was cordial formalities was over, and ultimately, my lord, I have completed the work, my lord. And my lord, lordship, kindly see, my lord, the part payments were made on, my lord, 2 occasions, on 16/1/2023, an amount of 41 lakhs, and on 16/9/2023, an amount of 16 lakhs something, my lord. Lordship will find it on page 37, my lord. 37. These are the part payments, my lord. 41 lakhs, and my lord, next is, my lord, 16 lakhs 57,587.
Total of 1 crore.
1 crore.
93,000.
Yes, my estimated cost, my lord, put to the tender was, my lord, 1,86,007,700, my lord. And my lord, my tender was accepted, my lord, and on an amount of rupees. That will find, my lord, in NIT, my lord, estimated cost is there, my lord, page 24, my lord. Page 24, middle, my lord. Name of the work, improvement of Kora to Mane Road under Nari PWD division. Estimated cost is 1 crore 86 lakhs 7,700. And my bid was accepted. Lordship will kindly see at page, my lord, 29, my lord. The letter issued by the executive engineer to my firm, my lord. Serial number 1, my lord. Your tender for the above mentioned work has been accepted on behalf of the governor of Arunachal Pradesh at your tender amount rupees 1 crore 67 lakhs 46,000 such and such, my lord. Only which is 3.67 below the justified rate of such and such, such and such. Thereafter, my lord, I was at serial number 3, my lord. On receipt of the prescribed performance guarantee, necessary letter to commence the work shall be issued and the site for work handed over to you thereafter. And accordingly, my lord, I have submitted my lord, the performance security at page 31, my lord, an amount of rupees 8,80,000 type is, my lord, top, my lord, right side, 8,80,692 rupees, my lord. And thereafter, on submission of the, my lord, performance security, my lord, I was directed to, my lord, complete the process of formal agreement with the, my lord, authority, my lord. Thereafter, my lord, at page 33, my lord, work proceed was issued to me, my lord, and site was handed over to me, page 33, my lord. May I read, my lord? In pursuance of the acceptance letter for your tender for work such and such, your firm is hereby handed over the site of the project. Therefore, you are directed to proceed to the work site and commence the work with immediate effect, my lord. Accordingly, my lord, I have, my lord, executed the, my lord, work for which, my lord, a part from payment was made to me, my lord. Two part payments were made, my lord. My lord has just seen that, my lord, page 37 and page 39, my lord. And my lord, work completion certificate is also given, handed over to me, my lord. Lordship will find at page 47, my lord. This is the certificate issued by the executive engineer, my lord. All the, my lord, components were 100% completed, my lord. So at this stage, my lord, may I pray that, my lord, notice may be issued, my lord.
Yes, madam.
Yes, madam.
You are for respondents?
Yes, madam. All the
All the
respondents.
respondents.
Yes, madam. All the responding, madam.
Yes.
Notice may be issued, madam. Notice may be issued, madam. Short date may be given, madam. I will bring on the records, madam.
Heard Mr. R. Soikia, learned counsel for the petitioner. And also heard Madam.
T.
Also
Wangmo.
learned. Government advocate for the respondents. In this petition under Article 226 of the Constitution of India, the petitioners has spread for issuing direction to the respondent authorities to make payment of admitted outstanding pending bills amounting rupees 1,28,93,479 rupees. Including the security amount against the work improvement of Pora to Mane Road under Nari PWD division. And also to pay, also for issuing direction to pay interest at the rate of 12% per annum from the date of execution of the contract. First, the petition and the documents plus in record. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by exam process. Notice be issued returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by Ms. So and receive notice. However, extra revised copy of the petition will be furnished to her during the course of the day. List the matter after 4 weeks.
Okay.
Lordship, I have received instruction, Lordship. Lordship, as per instruction, Lordship, if Lordship turn to the advertisement, there is page 22.
Yes.
In the column serial number, Lordship, 7. Serial number 7.
Mm.
The last
Last
date
date.
of submission of law.
Mm.
The petitioner did not submit in time, Lordship. He did not submit before on or before Lordship 13 November.
Mm.
And if Lordship come down the below Lordship, how to apply, Lordship will find in serial number 1.
Mm.
Willing candidates of Changlang district having requisite qualification may obtain or collect the application form from the office of the medical superintendent, district hospital Changlang on working days and submit it in same office with self-attested copy of the document, list of documents are given, Lordship. Then serial number 2, Lordship. The last date for submissions of the duly filled up application form is on or before 13 November, Wednesday till 2 p.m. An application received after due date or time or incomplete in any aspect will be summarily rejected, Lordship. Therefore, Lordship, if Lordship come to page 38, as per this advertisement, Lordship, the applicants, all the name of the applicants, Lordship, that have been finalized and list has been prepared at page 38, Lordship. This is the list of the candidates declared eligible for appearing walk-in interview post so and so. This is as per the application received in the office. These are the list, Lordship, where the petitioner's name is not there, Lordship.
If that was the position, why his name was listed in the this annexer 4?
Annexure 4.
Serial
Here,
number.
Lordship will find the name of the deputy commissioner is not there, Lordship. The signature is not there, Lordship.
Yeah.
Here. And as per instruction, it was not issued, Lordship.
It's just,
It was not issued by the deputy commissioner.
are you sure?
This is
No,
serious,
sir.
serious allegation, my lord.
It means that this is manufactured document.
This is, Lordship, in written Lordship instruction. Lordship, so far annexure 4 is concerned, 39, Lordship. Page 39, Lordship. Lordship will find on the down below SD is there, Lordship.
Pardon?
SD, in place of signature, Lordship, SD is given, Lordship.
As is given.
Yeah,
Yes.
and on page 38, Lordship will find, Lordship, the signature of
This is there.
district nodal official, Lordship. And as per instruction, Lordship, a clear statement is there, Lordship, from the authority that the application was not received before 13, Lordship.
Receipt
Not before up to 13, Lordship.
13.
Yes, Lordship. This is last date.
May I present a copy of the instruction will be furnished to me, my lord, so that I can go through, my lord. It's a very serious allegation, my lord. What my friend submitted, my lord, it can be
Better-
presumed that, my lord, I have manufactured this document, my lord.
No, Mr. Tapin,
Lordship.
you bring on record this instruction by filing an affidavit.
Lordship.
Huh? Heard Mr. Arsukia, learned complaint for the petitioner, and Mr. Tapin, learned senior government advocate for the state respondent. Number 1, 2,
Madam, I'll be appearing for respondent 1, 3, and 4.
1, 3, and 4.
Right.
And Mr. Tapin for respondent number 2.
Yes, ma'am.
So in respect of this, respondent number 5,
It's a private respondent.
private respondent.
The one who has been
Notice
selected.
Notice has to go.
Notice has
Notice
to
to
go.
go, my lord.
He has to be hard, Lordship, because he will be
Definitely.
affected, Lordship.
My lord, from this instruction, my lord, annexure A, it is the, my lord, instruction given by the, my lord, district medical officer to the deputy commissioner, my lord. Deputy commissioner, he himself is the chairman, my lord. How he cannot know that, my lord, that my list is not in the, my name is not in the list, my lord. Serial number 3, my lord. Sir, the candidate turned up for interview on 18 November during the walk-in interview, whereas his name was not in the list, my lord. I turned up there, my lord, on 18, my lord, but DMO said that, my lord, my name was not in the list, my lord. It is to, my lord, deputy commissioner is the, my lord, chairman, appointing authority, my lord. He has to give the instruction, my lord. Madam, record may be called from the office of the deputy commissioner, madam. Instead of madam issuing notice, thereafter madam may issue notice, madam.
If lordship see
The record of the selection
how
process may be
to,
called.
how to apply lordship. Here lordship, this application and all has to be submitted before medical superintendent district hospital, lordship Changlang lordship. Now, they are the lordship main department because it's a doctor is for the medical department only lordship. I am just only the lordship recruiting authority lordship. So application has to be filed before them lordship. Everything will be placed by them only to ask lordship. They have accordingly I sought lordship instruction from the exact figure lordship, the facts lordship from the district medical officer, and accordingly I have been furnished and I have forwarded to the to this honorable court lordship as an instruction. Anyway, I am ready to file affidavit in short date lordship.
This aspect has to be.
What is the record then?
Yes,
It can be
madam.
lordship, no issue. Lordship, otherwise, what records exactly lordship? Because most of the things are not disputed lordship. Suppose advertisement is not disputed lordship. Selection process is not disputed lordship. What
No,
record?
this, regarding this, receipt, date of receipt of application.
Date of receipt of application. Okay.
And also,
Let the
madam,
record come.
the revised list, madam. The revised list was published by deputy commissioner, madam. That's why I am saying, madam.
You delete this or what? Like issue notice. Person to order dated 2/12/2024, Mr. Robin, Lord and Senior Government Advocate, has produced written instruction before this court. Where is the same? A copy of which is also furnished to Mr. Soikia, Learned Counsel for the petition. Mr. Soikia, Learned Counsel for the petitioner submits that the record may be called for as in a written instruction, receipt of the application of the petitioner is disputed, and also annexer. What is the annexer, Mr. Soikia?
Page 39 or
Annexer
4, page 39.
Annexer 4 is also disputed. Whereas having considered the submission of Mr. Soikia, Learned Counsel for the petitioner, and also considering the facts and circumstances on the record, it is provided that Mr. Tapin, Learned Senior Government Advocate, shall produce the record of selection process before this court on when?
Lordship, next week.
Next week.
It has to come from Changlang district also.
Suggest on this.
Tuesday, madam. Next Tuesday, madam.
Tuesday.
Madam.
Tuesday, maybe. On Thursday, also.
Thursday.
Okay. On, can it be, madam, on 11th, madam, Wednesday, madam?
Okay, 11.
Obliged, madam.
Sanglang is not far away from here.
Changlang district also.
It's not far away.
No, it's very quite far.
No, nowadays, madam,
Changlang,
hardly takes 7 hours.
Changlang, I think, is the most farthest district also. Most, it's far.
No.
No.
You can go through Margarita.
Yes.
Margareta.
Yes.
By distance, I think it's the longest district from the
From
capital.
Margarita, it is hardly
Among the
1.5
district
hours.
lordship,
Bogeyville is there now, sorted.
that part is yellow. Road is good. That's different thing. So far, longest the road longest district having lordship, longest road lordship is this Changlang district. Is
No, from Margarita, it will be hardly 2 hours journey.
distance wise is if it's calculated among the district lordship is situated in the eastern part of the lordship, our state lordship. Margareta, it may be short, but here from this by distance it's the longest lordship road.
No, if you count it through Arunachal Pradesh, then it will be longest. But if we go through this way, Dibrugarh, Tinsukia, Margarita.
Anyway, lordship, 11.
Any other matter?
I don't know, 5.
Yeah, Lordship. Lordship, the Standing Council for the Tourism Department, Mr. N. Pada is, Lordship, not present today.
M?
N. Pada, Lordship, due to some domestic issues. So matter may be kindly listed after 3 weeks, Lordship.
And the interim may be continued, Your Lordship.
Pardon?
Interim may be continued, Your Lordship.
As agreed by learned advocates of both the parties, rest is the matter on. When?
Lordship, after 3 weeks.
Pardon?
3 weeks, Lordship.
After 3 weeks. Till then interim order was earlier self-containing.
Deeply obliged.
May I please, Your Lordship?
Yes.
My lord, this matter pertains to compensation of damage caused by the respondent number 2. That basically, my lord, the petitioner is a villager of Ramsing village, Upper Siam district, Your Lordship. He has a private property around 3,000 square meter, Your Lordship. And there was a earlier there was a boundary boulder wall which was constructed by his father in 1995, Your Lordship. Thereafter, the government, the PWD department of the Arunachal Pradesh initiated one road through Buirang to Ramsing village, Your Lordship. In that process, Your Lordship, the petitioner's boundary wall has been demolished by the respondent number 2 without prior intimation to the petitioner. However, my lord, when this process was initiated by the respondent authority, respondent number 2, the petitioner informed the respondent authority to intimate that kindly not to demolish his constructed wall, which has been which is a protected property of his fruit garden, Your Lordship. That was a fruit garden as well as a vegetable where the petitioner cultivated his vegetables as well as fruits, Your Lordship. So for that reason, he has for that demolition of the said wall, he has been suffered severe losses, Your Lordship. Thereafter, he intimated the said the damage caused by the respondent authority that to compensate him for his damage. So, my lord, there on Your Lordship, if Your Lordship go through my annexer, page number.
Yes, he has submitted the report.
No, Your Lordship, they did not done any inquiry as well as they did not pay any compensation to the petitioner till date, Your Lordship. However, the DC of the Upper Siam district sent a letter to the given an order to inquire the said damage caused by the respondent authority. However, till date, my lord, there was no any inquiry nor any call for the respondent authority to the petitioner to appear before them, Your Lordship, as per my instruction is concerned, Your Lordship. So, my lord, my respectful submission is that at least one inquiry may be conducted by the respondent authority and submitted before this honorable court as per that said inquiry report, he may be compensated by the concerned department which has caused the damage to the petitioner, Your Lordship. That is my humble submission before this honorable court. Page number 28, Your Lordship, Annexer 8.
Page number
28, Annexer 8. An order was passed by the Deputy Commissioner, Upper Siam District, to conduct an inquiry and given it the said order to the Extra Assistant Commissioner, Upper Siam District, Jennings, Your Lordship, to conduct an inquiry about the petitioner's loss. However, Your Lordship, neither the Extra Assistant Commissioner nor the DC has pursued it of this case, Your Lordship. And most importantly, Your Lordship, in their affidavit also, they did not say anything. regarding the inquiry report, as well as they done any inquiry also, your lordship. So that is the case, your lordship, that at least whatever I suffered loss, your lordship, that may be compensated by the responding authority. That is my humble prayer before this honorable court by this petition, your lordship.
Yes, madam, what is your stand?
Lordship, as per DC's order, your lordship, EAC has directed the PIE to conduct the preliminary inquiry on the matter, your lordship. And a report was also received from the PIE Jenging that the petitioner is not cooperating, your lordship. During the inquiry procedure also, he was not present, your lordship. He kept himself absent, your lordship. That is the reason, your lordship, inquiry could not be conducted, your lordship. And regarding this, your lordship, the honorable court on the last occasion has asked me to file additional affidavit also, your lordship, and I have filed, your lordship. May kindly see my additional affidavit, your lordship. In paragraph 3, your lordship, page 2.
Yes.
Paragraph 3, your lordship. That as per wide order dated 14/11/2003, the honorable court has directed the state respondent to file an affidavit bringing on record on the report that was received from the PIA Jenging on 15/4/2023. Paragraph 4, your lordship. Paragraph 3, your lordship.
Of additional affidavit.
Additional affidavit, your lordship.
Yes.
Paragraph 3.
Yes.
And that as per wide order dated 14/11/23, the Honorable High Court has directed.
Additional affidavit, paragraph number 3 is different.
It has filed on 14/12, your lordship.
14/12.
Yes. I have filed my main affidavit also, and
Yes, as per wide order dated 14/12.
yes, the Honorable High Court has directed the state respondent to file an affidavit bringing on record on the report that was received from the PI Jenging on 15/4/2023, countersigned by the head Gambura Ramsingh regarding the non-cooperation from the petitioner during the inquiry process, and that he had failed to make himself available by citing excuses of not being present in the station. Therefore, no inquiry report on the matter was submitted to the EAC office. Further inquiry has been put on hold as the matter is now sub judice. Your lordship, may kindly see the annexure 1, your lordship, at page 4. Type copy is at 5, your lordship. As per order mentioned above, the subject issued by the office, I tried many a times to inquire, verify the complaint received from Sri Agur Nangu of Ramsingh village, but he did not respond me and making excuses of not being present in the station. This is for your kind information to the office, as you have directed me to inquire the matter by 28/3/2023, and this is the final report submitted by me regarding the order issued by the office, your lordship. It is due to the petitioner himself, your lordship, we could not complete the inquiry, your
Why you are
lordship.
not cooperating with the PI?
My lord, this letter was never issued to me because I don't have, there was no any initial that I have received any letter from the respondent authority. Not a single notice has been served to me, your lordship. If that was served to me, they would have submitted by their affidavit also, your lordship. But there was no any notice. If I am correct, your lordship, in their affidavit is concerned, no notice has been served to me, your lordship. Not a single notice has been served till date, your lordship. But if they are willing to conduct an inquiry as well as to compensate me, then within a period of 7 days, they conduct an inquiry. I am going to.
He himself has filed the
going to
application
cooperate with
complaint
the
before
respondent
the DC,
authority.
your lordship.
Your lordship.
So we have directed to conduct the inquiry, and he is not present, your lordship.
Yes, yes.
And now he is asking for notice.
My lord, in the said notice, whatever my learned friend has submitted by in her additional affidavit, my lord, annexure 1, you kindly go through the letter. There was no any received by the petitioner or his family members. Is there any receipt that I have received the said notice or anything which has been conducted by the respondent authority?
You see, you are the petitioner of this.
Yes,
system.
Lordship. Your Lordship.
So your PR is to conduct an inquiry. If
Yes.
you are not cooperating with the authority, then
No,
what to do?
my lord, my prayer is that to conduct an inquiry as well as to pay compensation, whatever I have lost, your lordship.
Yes. We are
But
ready to conduct an inquiry, but you are not cooperating with
my lord,
them.
there was no any inquiry, your lordship. I have never communicated by the respondent authority as per my information is concerned, your lordship.
Your Lordship, after filing this additional affidavit, Your Lordship, on 7/5/2024, Your Lordship, the Honorable Court has directed the petitioner to get the instruction in respect of this additional affidavit. And if no necessary instruction is filed, then the writ petition shall be closed, Your Lordship. The direction was there, Your Lordship, on 7/5/24.
Yes. So if you are not cooperating, then we are closing the writ petition.
My lord,
Person to order dated 7/5/24.
my lord, we are ready to cooperate. However, no initiation has been done by the respondent authority. Yes, my lord, just one more prayer is that, your lordship, if on the next occasion they want to conduct an inquiry, then we are ready to cooperate with your lordship. That is my humble submission before this.
Let us fix it then.
Lordship.
On that day, he will appear before the
Lordship.
PI Zenning.
Yes, Lordship.
Definitely we are.
That can-
We are definitely appear before the Zening.
Heard me, sir?
SD your lordship.
Learned counsel for the petitioner and Madam Basak for the stateless complaint. Mr. Basak, referring to her additional affidavit dated. Dated 9th of August,
14/12,
14,
12.
dated 14/12/2023.
Yes,
23 or 4?
23, Lordship.
23. 14/11/2023. Submits that. As per direction of this court, referring to her affidavit dated so and so, submits that. As per report received from PI Zenning on Zenging on 15/4/2023. The petitioner has not been cooperating with the inquiry process, and he had failed to make himself available by citing excuses for not being present in the station, and therefore inquiry could not be conducted. And referring to order of this court dated 7/5/2024, Ms. Basar submits that as the petitioner has not been cooperating with the inquiry process, this writ petition may be closed. That is, Mr. Roy, learned counsel for the petitioner, submits that the petitioner is ready to cooperate with the investigating, with the PI's engagement. And though in the affidavit dated so and so, it has been stated that notice was issued to him, yet there is no signature of the petitioner in the said notice. And therefore, it is contended that another chance may be given to the petitioner by fixing a date, and if the petitioner fails to appear on that day, necessary order may be passed. In view of the submission of learned advocates of both sides, and also considering the facts and circumstances on the record, this court deemed it necessary to afford another opportunity to the petitioner to appear before the PI Zengings on or before
Date may be fixed, that date may.
After 2 weeks, Your Lordship.
Date may be fixed, Your Lordship. That will be good for the petitioner also.
On or before, Madam, suggest one date.
18, Your Lordship.
18.
Hmm.
On or before 18. And thereafter, the Miss Basser shall file an affidavit enclosing the said report, enclosing the report of the PI Zengi. List the matter on.
Much obliged, Your Lordship. Much obliged.
Any other matter?
My lord, here I'm appearing for the petitioner, my lord. In fact, I've been expressing urgency because of the petitioners are going to retirement, but my friend, my lord, is not yet filed the affidavit, my lord. So I'm facing some difficulty.
Yes, pardon?
In fact, on the last occasion also, it was
By next
reflected.
date, my lord, I'll sure. I may able to.
When the petitioners will be retiring?
Next year, my lord.
Next year?
My lord.
Next year, which one?
A month, my lord, I think in the mid of 25, my lord.
Made up 25.
My lord. Because here, my lord, what happened, my lord, my service
We have,
conditions have been altered, my lord. I have been posted in such a position, my lord, and now my promotional aspect, everything gone, my lord. Now my juniors, they have been promoted, my lord. They are drawing my higher salaries than me.
We have received.
File your
I have
affidavit.
received the instruction, my lord, that has been sent to waiting for law department, my lord. By next, my lord, 2 or 3, my lord.
Who are?
3, my lord. Same will be, my lord. I humbly believe, my lord, in position to file the affidavit, my lord.
2 or 3 weeks or 2 or 3 months?
No, my lord, 2 or 3 weeks, my lord.
Weeks.
2 or 3 weeks, my lord.
No, let there be a fixed date, my lord. Maybe let it be on January 15, 16, 15 or 16, my lord. By that time, January 15th. By that time, 2
Third,
weeks.
Mr. Desoki, Learned Counsel for the petitioner, and Mr. L. Parman, Learned Standing Counsel for the Agriculture Department. Mr. Parman submits that he has received instruction and he has prepared affidavit and sent the same to the law department for vetting.
My lord.
And therefore, Mr. Parman applies for granting him at least 2 weeks' time. Where is accordingly allowed recess unless the matter on.
Just may I pray, my lord, may aid that last chance, my lord. And in the absence of affidavit also, this can be taken up for disposal, my lord, on the next statement.
Okay. In the event of failing to file affidavit on next date, the court will proceed to hear and dispose of the matter without the affidavit of the state respondents. List on
15 or 16? January, man. 16. Obliged.
May it please your lordship. In this contempt petition, the pleadings are complete. This is regarding non-compliance of an order of the court for the past 2 years, my lord. The affidavit they have filed, we have given a reply. Your lordship, it's up to your lordship because I can prima facie show that by filing an affidavit, they are now trying to show that as soon as we got the order of the court, we complied with it. But it is otherwise. Because for the past 1 year in their affidavit, they say that we have instructed for a preliminary inquiry. It's a very serious case. My client was offered bribe by the district education officer to stop his complaint before the chief secretary. So the police, I immediately informed the FIR, filed an FIR, and the High Court directed that the SP conduct an inquiry on 12/7/2023. Since nothing was done, I file a contempt. My lord, at this stage, the report, the status, the present status of the inquiry will be a very relevant factor, because by simply filing an affidavit, the superintendent of police is assuming that the contempt it's a willful violation. We expect the officers to comply with the orders of the court and keep the majesty of the law. So I pray that your lordship may fix give a date of hearing as convenient, since I am an station lawyer.
My lord, I think we can hear it today itself, my lord. We can
No,
today hear itself, my lord. It's a very small issue, my lord.
If
My lord
the
will,
hearing
my
is
lord
to
will.
start today, my learned friend will have to produce the affidavit.
It's not required, my lord. The order is there, my lord. The question
Status.
is whether I have
Because the
violated the order
problem
or
with
not.
my lord, the problem with the council is that they represent the clients, we also, but they need not become so overzealous. Since the officer is there, means the contempt has to be closed today. My lord, we also have come to the court, before the court, to seek that the majesty of the court is respected. So I pray that the affidavit, let them give a status report. Heavens won't fall, because the contemptor won't be put to jail. The procedure of law will be complied with. So let them give a status report of the case and a date be fixed. That is my humble prayer, lordship.
May I please, my lord? My lord, if my senior counsel stores, my lord, I can explain it, my lord. If my lord turns to page 16 of my affidavit, my lord, there is the order, the order which they say that I have not followed, my lord. Page 16 of their affidavit, my lord, the contempt petition, my lord. 16. My lord.
Yes.
12/7/2023 is the order of the court, my lord. Left side top, my lord. The date on which this order was passed, my lord.
12/7?
2023.
That is not legible here, even it was there.
It is there. I mean, there is a date on which this order was passed, my lord. And 17E, what does it say, my lord? In view of the above, the following, and having regard to the nature of the prayer made by the petitioner in this petition, I hereby deemed it appropriate to dispose of this writ petition with the direction to the respondent of 4. Superintendent of Police, SIC, near information of this, so and so, to act upon the FIR that 29/12/2022 lodged by the petitioner in accordance with law. Now, what they are submitting is that, my lord, the contemptor has violated, not abide by the order dated 12/7/2023, my lord. There is their contention, my lord, and no action whatsoever has been taken, initiated against this order, my lord. Now, my lord, may kindly come to my affidavit, my affidavit reply, my lord. Para 8, my lord, para 11, my lord, page number 8, my lord, of my affidavit opposition, my lord.
11.
Para 11, my lord, page 8. Is the statement that I have replied to para 11, my lord. May I read it, my lord? With regard to the statement made in para 11 of the contempt petition, the answering deponent denies the same and further begs to state that, as per the mandate of section 17A of the PC Act 1988, when the complaint FIR dated so-and-so was received by his office, the deponent had white file noting dated 16/1/2023, my lord. Even before, my lord, the order of the High Court was passed, because I was, order of the Honorable High Court was passed on 17/7/2023, my lord. But on 16/1, before that order was passed, I've already acted, my lord, against that complaint, my lord, and forward the same to the Principal Secretary for Vigilance. And my lord is well aware, my lord, I cannot take cognizance, my lord, because there is a embargo under 17A of the PC Act, which says an approval has to be taken for the competent authority, my lord. I am the SP, my lord. The competent authority is the Vigilance Department, my lord. Until and unless I am given the approval, my lord, I cannot initiate any preliminary inquiry, or I cannot take cognizance of the case, my lord. There is an embargo, my lord. Therefore, my lord, on 16/1/2023, I sought for the approval, my lord, from the principal secretary. Pursuant to the approval under 17A, an approval came, my lord, of PCA was received by the office of the answering deponent, White, letter dated so on 12 July 2023, my lord. On the same day when this order was passed,
Now, what is the case is pending?
yes, my lord, we have already complied, my lord. We have, what does SIC do, my lord? A complaint has been filed, my lord. I take cognizance because I cannot inquire upon it, my lord. So I send it for an approval to the competent authority. They give me the approval. I have accepted the approval and I have already engaged one of my inspector to go along with the preliminary inquiry, my lord. That order has been complied, my lord. The order of the Honorable High Court was that the SIC should take action upon the complaint filed by the petitioner in accordance with law. But before that order was passed, my lord, I have already initiated the proceeding, my lord. It was under my, so where is the contempt, my lord? Now, my lord, sir, the senior counsel says, my lord, we need the status report, we need.
My lord, for 1 year, my lord, if I may say, I have documented.
Can you appreciate this is a contempt petition, my lord?
I'll have to counter
Whether
this.
there is a compliance with the order or not, that has
My
to be
lord,
seen, my lord. That's a simple
for
issue, my lord.
RTI, when we file an RTI, we got information that for other cases, the cases were registered and 12 and 10 number of cases were registered because they were
That is
corrupted
irrelevant, my lord. My lord,
in
can
the
you see this
education
order was
department.
violated
But
or not,
as
my lord?
regards my serious complaint, till they are saying the inquiry is going on. So I make a simple submission that for my satisfaction, let a status report be given. Why are they shying away from it? If on the next day, the status report says that case has been, progress has been made or persons has been, whatever has been done, then my case can come to an end. I'm not saying that. I am just asking them that what is preventing them from giving a status report? Because they have been saying we have given as soon as in paragraph 11.
Mr. Das, you tell me, is there any order in the order of this court? Is there any direction in the order of this court to furnish any status report or
Well,
about the status
furnishing of status report, my lord, the court, your lordship knows the prayers can always be molded.
That's all right,
because
it's a contempt petition, my lord.
In fact,
Mr. Das, this is not a writ petition. This is a contempt petition.
Yes, my lord, it's a quasi-criminal proceeding. But because they have been saying that for the past year, the matter, I filed the FIR 2 years back, and now they said 1 year, an inquiry is going on. So I just wanted if they can show us the progress of the.
Now, Mr. Das, you tell me when you will be available here.
Well, if your lordship, because I have some PIL matter where hearing are being fixed about a week from now, 3-4 PIL. If your lordship gives me that liberty, I want the matters to be fixed on that day. Well, I'll be available in Arunachal Pradesh after because from next after 1 week I'll be going out of the country after 10-15 days. So can it be after the Bihu?
Yes, no problem.
Well, I can see
my lord, subject to what my subject to my says, my lord.
Because I'll come for a physical hearing.
In my humble opinion, my lord, it seems it's a very frivolous application, my lord. My lord, I can show it on the face of it, my lord. In my affidavit, my lord.
Okay, we'll hear you. Let him come.
Yes, ma'am.
We have filed our, it's a contempt petition, my lord, and like, there is an allegation against an honest police officer.
Your lordship will take the final call. My learned friend should respect.
That I agree. Whatever, my lord, whatever my lord say, I'm here to
bound
by the orders and direction of this.
One liberty I'm asking as a counsel.
You apprise this court about the status of that case?
Yes, yes.
My lord, there is also here, my lord. It is, I have annexed it, my lord.
No, on that day you file it.
No, I've already filed it, my lord. My lord,
no, they have not given.
What they have saying, I have taken no action, my lord. I can show. I have taken the.
They are not telling that you are not taking any.
No, yes, my lord. I also know my limitation.
161 statement has been taken. We have seen certain documents, my lord. It is, I have annexed it in my affidavit of opposition, my lord.
Okay, on next that we will take a final call.
Yes, my lord.
Yes, yes. Let them place it. Why is it different?
Why should I file when it is a contempt petition?
Yes, my lord, if he doesn't file, that will go against
pointed out, my lord. It's not a writ petition. What, my lord, in my humble subject to correction, my lord, in my humble submission, what I really opine is that, my lord, whether the order was.
You are not legally bound, but
My lord.
what wrong would be happen if you file one status
Yes,
report on
yes.
that date?
Why? Because I've already filed it. It is in my
That's
affidavit.
right.
Therefore,
Up to date status.
my lord.
On that date, we'll take a final call on.
Then when my senior is ready, let him come
Yes,
and we
well,
can have a
I'll come
hearing
to Itanagar.
physically. My lord.
Physically.
Mr.
Because
Das,
I'll
you
be
suggest the date.
You suggest
Yes,
that, yeah, we
well,
can fix
the
the
date is 23rd of, it can be 21st and 23rd of January, Lord. After the Bihu. Well,
Okay,
Bihu,
okay.
Bihu.
Okay. Heard Mr. Das, learned counsel for the petitioner, and Mr. Opada, learned counsel for the contempt. List this matter on 21st of January 2025. In the meantime, Mr. Pada, learned.
It can be only, my lord, and endeavor will be taken up to dispose of the case on that particular day, my lord.
Okay. In the
Because-
meantime, Mr. Pada, learned counsel for the contempt now, shall file up-to-date status report of the case. What is the number of the case?
Yes, my lord, the number is contempt 6 of 24. Contempt 6, lordship.
Contempt.
Yes, my lord.
There is no case whatsoever, my lord.
My lord, that on that day we'll come to know.
Yes, yes.
Therefore, actually, there is unnecessary.
No,
my
no,
lord.
you have submitted your status report in
Yes,
this case.
yes. Here, my lord, because I've already annexed the documents along with my
My lord,
affidavit in opposition. There is no record, in fact.
My lord,
Okay. On
Only
that
an
day,
endeavor can be taken up,
on
my
that
lord.
day, an endeavor will be made to finally hear and dispose of this petition.
Exactly,
Yes,
my lord.
yes.
Deeply obliged.
Obliged, lordship.
Obliged.
Item number 9. Let us do it, right?
My lord, this is very short matter, my lord.
Short
I'll just highlight the brief fact, my lord, just nutshell. Thereafter, I'll just deal with the detail, my lord. The brief fact of the case, my lord, I was appointed on officiating promotion in year 2015, having attained the length of service, and on the regular on the pay scale, with pay scale, my lord, against a sanctioned post. Why it was officiating, my lord? Since there was no DPC held, my lord. That was, although I was only qualified and there was a vacancy clear cut, I was given officiating promotion because of non-conduct of DPC. Thereafter, regular DPC was held in year 2019, wherein instead of calculating, taking into account my length of service rendered in officiating the service right from 2015, they have count my service as a deputy director trade commerce on date of confirmation, on date of DPC on 2019, my lord. Now, my lord, in this case, my lord, there's the Katina decision, my lord, repeatedly Honorable Supreme Court has held that when the officiating appointment is regularized, it should be related back to the initial appointment. It should be confirmation, man. The service already rendered by the incumbent should always be taken into account for recording seniority in the service, my lord.
In the
This is
officiating position.
yes, my lord. Man, now this is the my lord, the brief, my lord, the case, my lord. I'll just on this premises, my lord, I'll just highlight, my lord. For just convenient, my lord, just synopsis. My lord, page 36, my lord. Page 36 of it. My lord, initially, I was working as a assistant district education officer in the education department, and there, my lord, in the year 2005, my lord, I was attached as ex officio assistant director in the Department of Trade and Commerce on administrative exigency without any further remuneration, man. But ordered at 13 October 2015, man, at page 36 of the petition, man. Thereafter, my lord, the government had created one post of deputy director and one post of assistant director along with other posts, man, in the Department of Trade and Commerce on 22 July 2009, man, which is annexed page 37, man. Now, against this created post, after creation, madam,
regular post of assistant director, my lord. The petitioner was appointed to the post of assistant director on deputation basis, my lord, on 18/11/2009, my lord, at page 38, my lord. Thereafter, my lord, the petitioner, since petitioner was taken on deputation, my lord, sent on deputation, finally the petitioner was released, my lord, from the parent department on 4th January 2010, my lord, to enable him to join in the borrowing department, that is Department of Trade and Commerce, my lord. Now, thereafter, my lord, petitioner was permanently absorbed as to the post of assistant director under Department of Trade and Commerce, my lord, on dated 24 January 2024, with effect from 4th January 2024. Now, thereafter, my lord, the government of Arunachal Pradesh has further created another post of deputy director, along with other posts in the department, my lord, on 20 October 2015, my lord. By this time, my lord, the petitioner has already qualified the length of service for regular promotion to the post of deputy director, my lord. My lord, the recruitment rule governing the deputy director, my lord, I will annex at page 28, my lord. As per this recruitment rule, my lord, it is the post of deputy director is filled up by 100% promotion from the assistant director, Trade and Commerce, who have completed 5 years of regular service in the grade, my lord. Now, the petitioner has completed regular service of assistant director, my lord, and he's already eligible, my lord, on 4th January 2015, he has already qualified, my lord, as per relevant recruitment rule, my lord. Thereafter, my lord, the petitioner, since petitioner is already eligible and there's a vacant post, my lord, he was given officiating promotion on 4th December 2015, my lord. My lord, then thereafter, my lord, that the government, state of government, Arunachal Pradesh have taken policy decision and by way of office memorandum, which is still in force, my lord, directing all the head of department to conduct a DPC within every 6 months to ensure timely promotion, my lord. Now, despite of this direction of the government, my lord, they have not conducted the DPC in time, my lord. But subsequently, my lord, DPC was held on 5/11/2019, my lord, and petition was recommended for regulation of officiating promotion to the post of deputy director from date of DPC, my lord, that is on 5th November 2019, instead of regularizing the same with effect from 4/12/2015, my lord, from date of initial promotion to the post of deputy director as on officiating basis, my lord. Now, in this regard, being agreed by this recommendation, my lord, since the seniority position of the petition has been ignored, now he's the only lone deputy director, my lord, in the entire department, my lord. And now I have been making requests to the authority, but that has not been considered, my lord, to count my length of service as a deputy director from that of my appointment as a deputy director, Trade and Commerce on officiating basis, my lord, with effect from 4/12/2015, my lord. Now, but this all the effort and request made by petitioner has not been considered. My lord, here, my lord, in this case, there are series of decisions, my lord, of Honorable Supreme Court, and I'll just rely on three of them, three of the decision, my lord. My lord, the first two, last three out of three, my lord, one case is arising out of decision of the on High Court, by way of SLP, my lord. The first, my lord, this Haresh Chandra Bhatia's case, para 7, my lord. I highlighted, my lord, that para 7, 11, 12, my lord. An officiating appointment for over a decade cannot be treated as a fleeting appointment with no service benefit to be given. Even after having rendered service equal to those of permanent appointee for a long period, and that too for proper functioning of the service, would be denied the benefit of the same for no cogent reason. Any other view is bound to have a demoralizing effect in the service as a whole. As appointment under Rule 25 are also to the duty post, which may form the part of the strength of service, because what has been stated in Rule so-and-so, we are of the view that the justice of the case and the need to preserve the efficient functioning of service would require to treat the appointment of respondent as a permanent, despite their having been first appointed on officiating basis. Next, my lord, 11. According to us, just and proper order to be passed would be to direct the appellant to treat the debt of the officiating appointment of the respondent as a debt of their regular appointment, and then to place them in the seniority list as required by Rule so-and-so. That is to interpose the direct recruit in the seniority in between two promotees as per their respective interstate seniority, and we direct accordingly. The seniority would therefore be refixed of all the concern, and not as per length of service alone, as ordered by tribunal, but as indicated by us. Before closing, it is required to be stated that we have not appreciated the stand taken by the appellant. This is for the reason that employees like the appellant, who are required to be a model employer, should not take a stand which is unfair. They have to treat both the wing of the service fairly, as both are equally important insofar as they are concerned. The need for making this observation has been felt because what we find is that despite an incumbent like respondent one having served for more than a decade following his appointment, the stand taken is that he should be taken to have become a member of the service from year 1984 and not from 1972, being oblivious of the fact that more than 12 years he had discharged the function of the higher post to the satisfaction of all concerned. Denial of such long period of service for the purpose of seniority is unjustified and arbitrary act which a model employer has to show. Now, my lord. Next, my lord. In my case, all regular pay I have been paid, my lord. This decision arising out of decision of our Honorable High Court, my lord. The Honorable Supreme Court, my lord, paragraph 15, my lord. 15, 17, 18, my lord. 15, my lord. It is well settled that even in case of probation or officiating appointment, which are followed by the confirmation, unless contrary rule is shown, the service rendered as officiating appointment or probation cannot be ignored for reckoning the length of continuous officiating service for determining the place in seniority list. Where the first appointment is made by not following the prescribed procedure, and such appointees is approved later on, the approval would means his confirmation by the authority and shall relate back to the date on which his appointment was made, and the entire service will have to become computed in reckoning the seniority according to the length of continuous officiation. In this regard, we fortify our view by the judgment of this court in so. Now, next, para 17 and 18. Seen from any angle, we are of the view that the learned single judge of High Court had rightly allowed the writ petition filed by the appellant with annexure number so and issued the appropriate direction. The full bench of High Court wrongly set aside the judgment of the learned single judge by wrongly interpreting the provision of law applicable in the case ignoring the judgment Batia's case, earlier just I referred, my lord, previous referred case, which squarely covers the matter so far as interpretation of the MPS rules are concerned. The judgment impugned in these appeal is based upon the conflicting and contradictory conclusion arrived at by the full bench. The assumption and presumption drawn are neither based on the relevant rules or supported by any official verdict of this court. 18, my lord. Under the circumstances, the appeal arising out of so-and-so, thing are allowed by setting aside the judgment of full bench. Writ petition filed by the appellant are allowed. The respondent directed to treat the officiating appointment of appellant as the date of their regular appointment and refix their seniority in terms of observation made in this judgment. Fresh seniority shall be prepared in the light of the direction along with the consequential benefit under law to the person who are found to be senior. In this case, all this even financial benefit I have already given, my lord. There's no quarrel, my lord. Now, next is, my lord, this is also a decision arising out of,
Is it necessary to multiply the authorities?
my lord.
One authority will.
My lord, that is suffice, my lord. That is suffice, my lord. This all, my lord, this becomes settled, my lord.
Okay, you furnish it to the court counsel. Yes, anybody from the respondent side?
My lord, I'm there, my lord.
My lord.
My lord, in service jurisprudence, we all know, my lord, regarding promotion, my lord, is not a fundamental right, but maybe legal right for consideration, my lord.
Consideration.
Yes.
No.
Now-
Consideration is held to be a fundamental right. Yes.
Yes, my lord.
Right to be considered.
Right to be considered, my lord. It cannot be made a
fundamental
demand
right.
type, my lord. Yes. Now, in any service, my lord, regarding promotion, appointment, now the guiding factor is the recruitment rules, my lord. Now, recruitment rules, as observed by the department, my lord, is well known, my lord. This notional, retrospective, these are seems to be alien to service jurisprudence. But when you say, my lord, in legal parlance, my lord, these are done repeatedly by the Supreme Court, my lord. Now, here is the case, my lord. Although the petitioners, my lord, now in this department, my lord, there are two sanctioned posts of deputy directors. One is senior to him, my lord, no doubt. And second, my lord, the petitioner is holding, my lord. Now, when he was given ad hoc promotion, my lord, admittedly, the department is not denying that as per recruitment rules, he has only qualified the length of service, my lord. Now, why we could not give the regular promotion? Because of, my lord, non-conduct of the DPs, my lord. Department says, my lord, if your lordship sees the department dates, my lord, they have given the 6-7 days. They try their best to, my lord, convene the DPC, either this way, that way, either chief secretary out of the station or the concerned commissioner out of the station, my lord. Because of that, my lord, they could not conduct the DPC on time, my lord. But ultimately, it was conducted, my lord. And while doing that, my lord, they have only considered, my lord, from the date of the official, my lord. Now we have to see, my lord, whether any giving him, my lord, this notional or retrospective promotion, my lord, as per the department is very clear that there are only 2 deputy directors. There will be no any seniority classes will be there, my lord. And he has been given, my lord, right from the ad hoc, my lord, that the financial benefit. Otherwise, what is most important giving any national promotion? Either financial benefit or seniority, my lord. These 2 things, my lord, we have to take very careful, my lord. Suppose giving someone national promotion, whether it will affect the seniority of others or not. Then, my lord, whether he'll be getting any undue, my lord, financial benefit or not. But here is the case, my lord, nothing is like that because there are only 2 deputy directors. One is only senior is holding the post, the another is the, my lord, petitioner, my lord. Now, if your lordship sees, my lord, the government affidavit, exactly what I have said, that is the extent of the department, that this national and all these things are, my lord, alien to the service jurisprudence, which of course, my lord, in today's legal parlance, my lord, this may not be acceptable. We have seen right from the that if I correctly remember, the 2024 that Poonam case, my lord, regarding my lord retrospective promotion, my lord, in certain circumstances, yes, it can be. In certain circumstances, my lord. Now, what could be the circumstances, my lord? Whether, my lord, the DPC could not be considered on right time, whether the petitioner is eligible or not, my lord. Whether he's giving any my lord, national promotion, will that national promotion affect the others or not? All these parameters, my lord. If it does not affect the other side, then it may, my lord. In another special circumstances, my lord. Otherwise, in legal service jurisprudence, my lord, it cannot be done. My lord. If there is any side effect giving to the petitioners, my lord, because that will affect the seniority, my lord. If it does not affect the seniority, my lord, then, my lord, for financial any undue benefits, my lord. Suppose someone is given the national promotion without holding that post, definitely, my lord, he'll be claiming the, my lord, number one, the financial benefit. Then come the seniority, my lord. But here the case is something different, my lord, what I have seen, my lord. But that is the extent of the department. If your lordship see, my lord, page 4 of the affidavit. Since, my lord, 2019, my lord, 16.5, if your lordship met.
Page number?
Page number, my lord, operative is 98, my lord.
98.
Yes, my lord. They have attempt, my lord. 16.5/2009. This was the first attempt, my lord.
These are the dates of DPC.
Yes, they tried to, my lord, conduct the DPC, but they could not. Ultimately, my lord, they succeeded only on, my lord, 15/11/2019, my lord. That is, my lord, 100, page number 100, if your lordship comes. 100. So after several attempts, my lord, finally they succeeded. That is also 8 attempts, my lord. That's what department says, my lord. Though finally they succeeded, it was held on 5/11/2019. And from this date, my lord, they have considered his regularization, my lord. My lord, maybe.
Not from the initial date.
Not from the officiating, my lord. Not from the officiating, my lord. Whereas, my lord, out of the record, my lord, it's perceived something went wrong because he was already qualified as per the recruitment rules, my lord. He was already given the financial benefit. He was given, my lord, the financial benefit of deputy director, my lord. I think that part was, while setting the DPC, it was not placed properly, I think. Not placed properly. And another matter, whether the recruitment rules, my lord, whether he qualifies or not, whether there will be any side effect or not. Say, example, seniority, giving him any, my lord, retrospective promotion. I think all these things were, seems, my lord, the DPC, my lord, committee, it was not placed properly, it seems, my lord. They simply said, my lord, okay, from this date, DPC was held and you will be regular from this date. Rest, my lord, it seems, my lord, it was not either placed properly or not considered, it seems, my lord.
So the minutes of the meeting of the DPC is not clear about it.
My lord, that's the officiating service has not been taken into account, my lord. Maybe because of the fault of the department.
Is it expressed in the minutes?
My lord, it is not there, my lord.
My lord, it was not said anything about his, my lord, previous service, my lord. The financial upgradation, everything was.
In view of these judgments referred by him.
My lord.
So that can be.
That can be reconsidered.
That have been considered.
Yes, my lord. Yes, my lord. That can be reconsidered, my lord. Placing all these records, my lord.
Then we can dispose of the petition by directing the DPC.
For re-DPC, my lord.
Yes.
Placing all these records, my lord. Yes. That can be
For
done.
considering his length of service rendered in officiating since 2015, my lord. That, my lord, that aspect.
The DPC will re-DPC will look into.
Yes, yes, my lord. Yes, my lord.
Because I was thinking, my lord, whether suppose giving him retrospective promotion, the other seniority will be effect or not, my lord. But here's the case, my lord. There is only two, as I said, two deputy director. So there will no any seniority problem, my lord. Even the pay scale, right from the ad hoc, my lord, it seems he has been already, my lord. Then nothing left, my lord.
Even for default of.
For the purpose of seniority.
Yes, only because financial I got, man.
Finance already Mali getting the benefit right from the beginning, my lord.
Well, dispose of.
My lord, because of default of the authority, my lord, I should not help suffer, my lord. Even law department, they comment in my favor, my lord.
Is it available in your petition?
Yes, my lord, the page 64, it start from 61 and relevant operation is page operative portion, page 64, my lord,
Page 64.
of my writ petition, my lord.
64.
My lord, just, they've got the Supreme Court decision of Hemraj Singh Chauhan also, my lord, page 64. I just read, my lord. It would be further relevant to refer to judgment of the Supreme Court in so and so, wherein it was observed and held that the court can, especially having regard to the power under 142 of the Constitution, give suitable direction in order to mitigate a hardship and denial of legitimate right of the employed. The court is satisfied that in case for a delay exercise of the statutory function, the government has not offer any plausible explanation. The respondent cannot be made any way responsible for the delay. In such situation, as in instant case, direction given by the High Court cannot be said to be unreasonable.
Okay.
In view of above, my lord.
We'll pass the order.
My lord.
And disposing of this person.
Deeply applied, my lord.
Yes.
Lordship, may have it, please.
Sorry.
This is the case, my lord, of second inquiry.
Second?
Second inquiry. Second inquiry, the inquiry was, disciplinary proceeding was initiated against the petitioner.
Second inquiry?
I'll put it, my lord. It's the briefly stated, my lord, the case is like this. Disciplinary proceeding was initiated against the petitioner. The inquiry officer, in his inquiry report, held the charges not proved and exonerated the petitioner. The disciplinary authority accepted the inquiry report and accordingly exonerated the petitioner. Then, my lord, what happened was, since when the petitioner was under suspension, at that very point of time, my lord, there was a DPC because petitioner was already due for promotion from sub-inspector to inspector. Since at that very point of time, departmental proceeding was pending, so the DPC kept its recommendation under the sealed cover. So it was under sealed cover.
No.
There are, I'll put it this way, my lord.
No. After exoneration, what happened?
That's why. After exoneration, I'm linking the two things. I'll just put it this way. Number one, suspension. When he's under suspension, there is a DPC. He is due for promotion already. DPC kept its recommendation in sealed cover. Inquiry is initiated thereafter. Inquiry is completed. Inquiry officer exonerated him. Charges not proved. Matter goes to disciplinary authority. Disciplinary authority says, yes, inquiry officer's recommendation report accepted. Accordingly, now the direction goes that sealed cover be opened. Now, my lord, the procedure is over there. As per their own process, the matter had gone to the DGP, Director General of Police. Now, Director General of Police exercises his special powers. The review, I'll go to the nature of the power itself, whether the scope of the power permits such an action. The DGP says, I do not accept the disciplinary authority's action of accepting the report of the inquiry officer. I do not accept even the report of the inquiry officer of exonerating him. This is a fit case wherein another inquiry be initiated.
So, my lord, he passes an order for initiating an inquiry, and what he does, he himself appoints an inquiry officer. He also directs that recommendation would remain in sealed cover. Nothing will be done so far as the promotion is concerned. This action of DGP is under challenge in the presented proceeding. This is what the whole case is all about.
Can he appoint the inquiry officer?
He cannot, because, my lord, if an authority as high as DGP appoints an inquiry officer, he's superintendent of police, he appoints him, my lord, inquiry officer would be under pressure. He would naturally do what the DGP wants him to do. In any case, my lord, the principle of law is well settled. It is not open to order an inquiry, a second inquiry, in respect of the same charges which were held not proved and accepted by the disciplinary authority. One cannot order a second inquiry. Second inquiry can be ordered when some relevant evidence left out, not considered, or some relevant evidence is to be collected, some further inquiry is required. That is not the nature of the finding given by the DGP in the impugn order. I'll show the order of the DGP, my lord. Straight away, I'll come to the impugn order. The impugn order of DGP, my lord, will find (18/4/2024), Annexure P7, page 44-45 of the writ petition. Initially, my lord, he has quoted the charges, Article 1, Article 2, Article 3, etc. Then, my lord, I will read, my lord, immediately after Article 3. Article 3. And whereas Sri Nikom Riba, Ditan DYSP Crime PHQ Itanagar, was appointed as inquiry officer to inquire into the charges leveled against Inspector Minli Gai and SI Sushant Saurabh Jha, by order dated 28/9/2023. After conducting the departmental inquiry, the inquiry officer has submitted the inquiry report with findings. The charges leveled against Inspector Minli Gai and SI Sushant Saurabh Jha not proved. And whereas the disciplinary authority, Superintendent of Police, Nahar Lagoon, while acting on the findings of the inquiry officer, discharges Inspector Minli Gai and SI Sushant Saurabh Jha from the charges leveled against them and treated, I repeat, my lord, and whereas the disciplinary authority, Superintendent of Police, Nahar Lagoon, while acting on the findings of the inquiry officer, discharges. This is what he did naturally, discharge him. Discharges Inspector Minli Gai and SI Sushant Saurabh Jha from the charges leveled against them and treated their period of suspension with effect from 14/7/23 to 22/11/23 as spent on duty while order number such and such. This is, he's referring to the order of disciplinary authority. On perusal of the DPC recommendation, so my lord, the recommendation of DPC was also perused. DPC's recommendation was for promotion when sealed cover was opened. On perusal of the DPC recommendation for the promotion of SI Sushant Saurabh Jha from sub-inspector to inspector, it was found that the charges leveled in the departmental inquiry initiated against SI Sushant Saurabh Jha and Inspector Minli Gai has been exonerated by the disciplinary authority such and such, while order dated such and such, on the basis of the findings of the departmental inquiry report submitted by the inquiry officer. Now, my lord, comes the core. The charges leveled against SI Sushant Saurabh Jha and Inspector Minli Gai were very serious in nature. As the next page, my lord, page 45. The charges leveled against SI Sushant Saurabh Jha and Inspector Minli Gai.
Mr. Tewari, you
My
tell
lord.
me, this file went through DGP
Yes.
only in connection with approval of the DPC.
Yes, my lord. This is another ground we have taken. Because it goes in connection with the promotion, and he looks into everything, and then he opens up. Now, my lord, the argument is the relevant provision which he has referred to. I will read that provision also. The argument is he has that power, the so-called inherent power of the DGP, the power of reviewing anything at any point of time. I will come to that. May I straight away come to the relevant provision, my lord? I'll come to that.
एक minute.
My lord has been quite kind because I was told that lordship is supposed to possibly attend some ceremony in the evening.
Yes.
So,
Finish it.
but my lord, I have my submissions, case laws, everything I have referred. So that is it. So my lord will find this. The impugn order. I'll come to the rule itself. The rule I have annexed. The entire copy you have. Page 46. The relevant portion, my lord, we have annexed over here. The complete rule is available. Give it to your lordship, my lord. The complete, the entire set. (46) is the relevant portion.
Yes.
So, my lord, the entire thing, lordship would see the internal page, page 49. Page 49 is the running page in the writ petition, please. Rule 31 is the rule under which power has been exercised.
Page number?
Running page 49 of the writ petition. So far as the below entire rule that we have given to your lordship, there my lord will find internal page 23.
Page 49.
Yes, page 49, rule 31. Rule 31, sub rule 1, the DGP may at any time call for the records of awards made by any of his subordinate, either on his own motion or otherwise, and confirm, enhance, modify, or annul the same, or make further inquiry, or direct such inquiry to be made before passing orders, provided that no action under this sub-rule shall be initiated more than 6 months after the date of the order sought to be reviewed, except with the prior approval of the state government. Sub-rule 2. If an award of dismissal or removal from service is annulled, the officer annulling it shall state whether it is to be recorded as suspension followed by reinstatement or not. The order shall also state whether service previous to dismissal or removal shall count for pension or not. 3. In all cases in which an officer proposes to enhance punishment, he shall, before final passing, there is a typographical error over here. It should be before passing final order. Before passing final order, give the charged officer concerned an opportunity of show cause in writing, including personal hearing if asked for, as to why his punishment should be enhanced. Now, my lord, I'll begin from sub-rule 3, 2, and then I'll go to 1. Reversely, I'll proceed. Let us begin with sub-rule 3, my lord. Sub-rule 3 is a case wherein punishment may be enhanced, enhancement of the punishment. Now, for enhancement of the punishment, before passing final order, the charged officer is entitled to get a show cause, if necessary, a personal hearing as to why punishment should not be enhanced. So, natural justice is embedded so far as sub-rule 3 is concerned. Over here, my lord, it is not a case of enhancing the punishment. So, sub-rule 3 is given a go-by. Now, pausing here, my lord, I also clarify, here is a case I was never heard. No show cause, nothing of the kind. Completely in violation of natural justice. But my lord, my submission would be, here even natural justice is not required. The power which has been exercised in my case could not have been exercised even by issuing a show cause notice, which of course he did not do. So, sub-rule 3 is ruled out. Now, I come to the sub-rule 2. If an award of dismissal or removal from service is annulled, so naturally, my lord, if somebody is dismissed or somebody is removed from service And if the order of dismissal or removal is set aside, naturally, my lord, that person will not be aggrieved. So while setting aside the order of dismissal or setting aside the order of removal, opportunity to show cause need not be given. It is understood. Because practically, my lord, the concerned accused officer, the officer who's already been punished with the order of dismissal or removal, he is getting the benefit. His order of dismissal is being set aside. So he is not required to be heard for that purpose. DGP can exercise such a power. This is what sub rule 2 is. But order shall state whether service previous to dismissal or removal shall count for pension or not. So, my lord, sub rule 2, no natural justice is needed. Sub rule 2 is also not attracted in the present case. Now let us come to the sub rule 1. Sub rule 1 is the only provision under which possibly DGP could have acted. Now, what the sub rule 1 says, again I'll read. The DGP may at any time call for the record. So he has the power. Somebody may whisper in his ear, something wrong has taken place somewhere, you call for the file. So he has the power. Record of awards made by any of his subordinate, either on his own motion or otherwise. This, my lord, I will read as subordinate is a disciplinary authority. Disciplinary authority is subordinate to the DGP naturally in this case. He gets somebody whispers him that in this very particular case, disciplinary authority accepted the inquiry officer's report and man is totally exonerated. He calls for the file straight away. On his own motion or otherwise, then confirm, enhance, modify or annul. Confirm, that is, confirmation is not a case. Enhancement is not a case. Modification is also not a case. This is a complete annulment. Complete annulment of the action of the disciplinary authority and action of the inquiry officer. Annul the same or make further inquiry. Now, not this word further inquiry is very vital. The further inquiry is a de novo inquiry, meaning thereby some blunder took place at some stage of the inquiry, some vital evidence could not be collected, something big happened. Supreme Court envisages such a situation, I will place the judgment. So further inquiry, oh, this aspect not gone into. So further inquiry concentrated for that purpose. You can't initiate a fresh inquiry by appointing another inquiry officer of your choice. Because DGP is the highest ranking officer in police. If DGP says Mr. X is now the inquiry officer, Mr. X is obliged to follow the diktat of the DGP. Or make further inquiry. So further inquiry is not a case of further inquiry. Further inquiry is a de novo inquiry. Or direct such inquiry to be made. Now, my lord, my interpretation would be direct such inquiry. The such inquiry would have to be read as further inquiry only. It cannot be fresh inquiry or inquiry from the very inception. I will place judgments. Such inquiry to be made before passing orders, provided that no action under this sub-rule shall be initiated more than 6 months after the date. Of course, period is not relevant because it was within the 6 months period. So, my lord, this is what he did. The only question is whether in the present case, DGP could have exercised the power under Rule 31, Sub-Rule 1, the so-called power of review, so as to annul the order of disciplinary authority, so as to completely set aside the report of the inquiry officer, and whether he could have directed a fresh inquiry. Now, my lord, my further submission would be, so far as Sub-Rule 1 is concerned, my lord would note that no principle of natural justice is embedded over here. Though no principle of natural justice is embedded over here, the natural justice has to be read here. Because you can't suo moto, because I am a beneficiary of the report of the inquiry officer. I am also the beneficiary of the order of the disciplinary authority. I was exonerated of everything. Without hearing me, suo moto, you do it. So that is defect number 1. But the second aspect would be whether he can exercise such a power.
Principle of natural justice has not been complied with.
But, my lord, in case if lordship says now comply with the natural justice, it would amount to giving a concession that yes, you have such a power that you can do it. My submission would be, even by complying natural justice, this power could not have been exercised in the present case. Because further inquiry is a de novo inquiry. You can't initiate fresh inquiry. You can't completely do away with the report of the inquiry officer, order of disciplinary authority, and appoint an inquiry officer also. That is the power of disciplinary authority. That apart, my lord, there is another aspect to the case. DPC acted under the service rules framed in the proviso to Article 309. Those are separate statutory rules. DPC is finding captain sealed cover. Now, my lord, here the DGP is exercising his powers under a different set of rules. Again, framed under proviso to Article 309, exercising his power of review under the discipline and appeal rules, he is interfering with the order, with the recommendation of the DPC. The DPC was also a statutory body under proviso to Article 309 rules. I will be placing those rules also. That has been done away with completely. So, my lord, this is a case of a sanctioned inquiry. The Supreme Court says there is a limited scope. There can be a de novo inquiry when some vital evidence has to be collected, could not be looked into, could not be collected. So further inquiry can be, or if there is some very big defect with the inquiry. In such a situation, to rectify the defect, the power is vested to initiate de novo inquiry from the stage so as to correct the error. But you can't initiate a fresh inquiry in respect of the same charges. That would be second inquiry, which is ex facie illegal. Now, my lord, I'll come to my submissions. Submissions, my lord, I have written that my lord will get it. Four submissions, my lord, I will just read. Submissions, internal page 4 of my write-up. 1. The Director General of Police exercised the power of review under Rule 31(1) of the Arunachal Pradesh Police Discipline and Appeal Rules 1999 in violation of the principles of natural justice, and as such, the impugn order such and such ab initio void. But my lord, I am traveling beyond it because I know it's DGP. So only for natural justice, my lord, only this ground if I take, I will be back to square one. Then comes the second submission. Rule 31 sub rule 2. I have dealt with this rule. What is the scope of this rule? Rule 31 sub rule 2 of the 99 rules deals with the situation when the Director General of Police annuls the award of dismissal or removal from service. Since annulment of the award of dismissal or removal from service is beneficial to the charged officer, it is natural that there should be no requirement to provide an opportunity of hearing to the charged officer by the Director General of Police. Likewise, Rule 31 sub rule 3 of the rules provides for those cases where the Director General of Police proposes to enhance punishment. Since punishment imposed is sought to be enhanced by the Director General of Police, Rule 31 sub rule 3 makes it mandatory that the Director General of Police issues a show cause notice in writing and provides personal hearing to the charged officer before enhancing the punishment. Therefore, even though the principle of natural justice is not embedded in Rule 31(1), the same has to be followed if the power thereunder is exercised to the prejudice of the subordinate officer. Then, my lord, the impugn order dated 18/4/24 has the effect of initiating a second inquiry against the petitioner in respect of those very charges that were held not proved in the earlier inquiry. Therefore, the impugn order initiating the second inquiry against the petitioner on the same charges which were held not proved is contrary to the settled principle. Now, my lord, Supreme Court is very, very categorical in all the three cases. I have given the relevant paragraphs. Paragraphs are not given. I'm sorry. Kindly. Again, my lord, they have left out. So far as, my lord, the first judgment is concerned, 2006, 12 SCC, page 28. 2006, 12 SCC, page 28. The relevant para is paragraph 18. Para 18. I'm sorry. Please. Kindly. Paragraph 18. Page 28. Para 18 at page 32, my lord. Page 32, internally. 2006,
Yes.
volume 12 SEC,
Paragraph number?
para 18, 18.
Yes.
We agree with the learned counsel for the respondent that if the charge which has been labeled under the memo dated 23/12/2003 had earlier been inquired into in a regular inquiry by a competent authority, and if the respondent had been exonerated on that very charge, a second inquiry would not be maintainable. However, in the present case, we are of the opinion that the charges leveled against the respondent under the charge memo dated such and such had not been inquired into by any authority. That was a distinguishing feature. Here, that is not the case. My lord will find from the inquiry officer's report, which I have annexed over here. And he had not been exonerated on those charges. I was exonerated of all the charges in the report of the inquiry officer. Hence, we are of the opinion that it is not a case of double jeopardy. So, my lord, if it is otherwise, it will be a clear case of double jeopardy. Then the next judgment I am referring to is Union of India versus KD Pandey, 2002, volume 10 SEC. 2002, volume 10 SEC, 471, Delhi. This is para 3, 4, and 5. Paragraph 3, paragraph 4, and paragraph 5. Page 472, 3, 4, and 5.
Yes.
I start from the para 3, my lord. That will give the entire background. The proceedings were initiated against respondent 1 in respect of 6 charges. The inquiry authority in the report made held that none of the charges stood proved. Thereafter, the Railway Board, in exercise of powers under Rule 25 of the Railway Servants Discipline and Appeal Rules 1968, examined the matter and found that 4 of the 6 charges could be substantially proved beyond doubt with the available documentary evidence, and thereafter remitted the matter for further inquiry. This is vital, for further inquiry, as contemplated under Rule 25 1C of the rules. On remit, the inquiry officer made a report finding respondent 1 guilty of 4 charges. Based on that report, the Railway Board dismissed respondent 1, which was challenged in the dispute raised by him. The tribunal as well as the High Court are of the view that on the same material, a fresh opinion has been furnished, and it was not a case of further inquiry. Indeed, it was not noticed by the disciplinary authority that the inquiry held earlier was bad, or that the management or the establishment did not have the proper opportunity to lead evidence, or the findings were perverse. I'm not pausing here. I repeat this sentence. The court clearly says it was not noticed by the disciplinary authority. Below, the same is the case here also. My lord will find from the impugned order, disciplinary authority has not noticed that the inquiry held earlier was bad. If it was bad, why it was bad? Or that the management or the establishment did not have the proper opportunity to lead evidence, or the findings were perverse. In the absence of the same, it was held that there was no justification on the part of the disciplinary authority to commence fresh inquiry on the same set of charges. Then comes the, my lord, the finality. Learned counsel for the appellant contended that in this case, the board had examined the material on record and come to the conclusion that 4 of the 6 charges could be proved on the available material, which had not been properly examined in the earlier inquiry. In fact, from the order made by Railway Board, as well as from that part of the file where the inquiry report made earlier is discussed, it is clear that specific findings have been given in respect of each of the charges after discussing the matter. And if that is so, we fail to understand as to how there could have been a remit to the inquiry, authority for further inquiry. The Supreme Court did not even accept the further inquiry. Indeed, this resulted in second inquiry, the Supreme Court says, and not in a further inquiry on the same set of charges and the material on record. If this process is allowed, the inquiries can go on perpetually until the view of the inquiry authority is in accord with that of the disciplinary authority. You know, that is my case here. You appoint an inquiry officer of your choice because you want his opinion in accordance with your opinion. And it would be the abuse of process of law. In that view of the matter, we think that the order made by the High Court affirming the order of tribunal is just and proper, and therefore we decline to interfere such and such. The third judgment I am referring to, my lord, is 2007-11 SEC. 2007-11 SEC. Page 517, the relevant page, para 6. para 6 and para 7, in fact, my lord, because in para 7, Supreme Court referred to its earlier judgment in KR Dev case. On practically the same principle, para 6, I read, the question as to whether a punishment of confinement to civil lines could have been directed or not should not detain us, as we agree with the contention raised by the learned counsel for the appellant that the purported order dated 5/4/95 of the disciplinary authority was unsustainable in law. Rule 27 of the Central Reserve Police Force Rules 1955 inter alia lays down the procedure for conducting a departmental inquiry. Once a disciplinary proceeding has been initiated, the same must be brought to its logical end, meaning thereby a finding is required to be arrived at as to whether the delinquent officer is guilty of charges leveled against him or not. In a given situation, further evidence may be directed to be adduced, but the same would not mean that despite holding a delinquent officer to be partially guilty of the charges leveled against him, another inquiry would be directed to be initiated on the self-same charges which could not be proved in the first inquiry. Here, my lord, none of the charges could be proved and totally a fresh inquiry directed. You look into everything. In KR Dev versus CCE, this court, while considering the provisions contained in Rule 15(1) of the CCS Classification and Appeal Rules 57 held as under, it seems to us that Rule 15 on the face of it really provides for one inquiry. But it may be possible if in a particular case there has been no proper inquiry, if there is no proper inquiry, because some serious defect has crept into the inquiry or some important witnesses were not available at the time of the inquiry or were not examined for some other reason, the disciplinary authority may ask the inquiry officer to record further evidence. We're not pausing here, I'll clarify. This is not the case here. It is not the case of DGP that there was no proper inquiry, that there was some serious defect which crept into the inquiry or some important witness were not available and now they are available and you have to record their evidence. But below, in that case, there will be further inquiry only. There can be de novo inquiry. There could be a limited inquiry. There can't be a fresh inquiry. So, my lord, is completely setting aside what watching everything practically and initiating a fresh inquiry. Now, my lord, comes the the fourth submission of mine in internal page 5. This I have interpreted Rule 31 Sub-Rule 1. The power under Rule 31 Sub-Rule 1 does not envisage initiation of second inquiry on the same charges which were earlier held and not proved in a regular inquiry. It only envisages making quote-unquote further inquiry. The expression direct quote-unquote such inquiry, because my submission was even the such inquiry has to be understood as further inquiry. The expression direct quote-unquote such inquiry used in Rule 31(1) cannot be construed to mean a second inquiry and can only be construed to mean further inquiry. The power under this rule can only be exercised if in a particular case there has been no proper inquiry because some serious defects have crept into the inquiry or some important witnesses were not available at the time of the inquiry or were not examined for some reason. My lord, I am relying on KR Dev for such expressions. In such a case, the reviewing authority may ask the inquiry officer to record further evidence, but there is no provision in Rule 31(1) for completely setting aside the previous inquiry and the order of disciplinary authority accepting the report of such inquiry on the ground that the earlier inquiry report and the order of disciplinary authority accepting the report doesn't appeal to the reviewing authority. So merely because it doesn't appeal to you, you can't direct that, no, we don't accept it.
No. That interpretation whether would be permissible because in the rule it is review 31.
Yes.
Sub-Rule 1. You see, on own motion or otherwise.
Yes, otherwise, but below that otherwise. Ultimately, my lord, it would violate the very tenet of Article 14. DGP is not a dictator. On ipse dixi, he can't, my lord, it may be a case. Imagine a situation. I am a police officer. For some good reason, there is no good chemistry between self and the DGP. He wants to fix me up. My lord, if we give such an interpretation to Rule 31(1), it would amount to giving unbridled discretion to the DGP. Giving him unbridled discretion.
No. He may not direct a fresh inquiry.
But this is what he has done.
No. I am on the point of this otherwise. Though it is not placed before him as a reviewing authority or otherwise, but it was placed before him.
Yes. If it is placed, my lord, because he can even call, somebody may tell him about something, he comes to know through somebody, then he can always call for the file. So, my lord, the power is, he has been given practically the unbridled power under Rule 31(1). But the question is, to what extent you will go? My submission would be, DGP at the most has the power to direct de novo inquiry or such further inquiry, but then in that very case, he will have to show as to what has gone wrong with earlier inquiry.
Definitely.
He will have to carve out the area of exception. Because, my lord knows there is another principle in service jurisprudence. Disciplinary authority can always disagree with the findings of the inquiry officer. There the judgments of the Supreme Court judgments are, if the disciplinary authority doesn't agree with the report of the inquiry officer, the disciplinary authority will have to issue the show cause to the charged officer and tell him the area of difference.
In that case, they have to report disagreement note also.
Yes, that is a requirement, my lord. He will have to carve out the area of difference. Point out, this is the area.
Why he disagreed?
Here, my lord, under Rule 31(1), it is unbridled power. The discretion, my lord, is an unfettered discretion. It's a discretion of the DGP. As to how he is exercising the discretion, that is an issue, my lord, for my lord's consideration. Here, my lord, he exercises the discretion in a manner, my lord, which can only be called arbitrary. The reasons that he has given are not sufficient reasons at all in the eye of law. That is it, my lord. The satisfaction is a subjective satisfaction. The satisfaction is not objective, based on credible materials. My lord will see what he says. So, my lord, anyway, there is another case. Both the cases are similar. In this case, the petitioner was sub-inspector. In the other case, the petitioner was inspector. The only difference between the two cases, in the present case, he was also eligible for promotion to inspector. So there was recommendation of DPC was in a sealed cover. In other case, there is no such DPC, no such sealed cover, no such case of promotion. Simple inquiry, and this happened. Practically, my lord, both of them.
How the matter is DGP?
Same thing, my lord. Actually, both. It was case of, my lord, joint inquiry. In inquiry, these two were charged officer. So by a common order, my lord, both have been fixed up. Both have been fixed up. The only thing, my lord, in this case, even the promotion aspect also gone. So other officer, the issue of sealed cover is not there. So practically, my lord, it is a question of interpretation of Rule 31(1). My submission would be, the Rule 31(1) can't be read in a manner so as to give or confer unbridled discretion to the DGP. In the eye of law, my lord, nobody can be a dictator. A DGP is not above the law. And Rule 31(1) cannot be interpreted to mean that DGP has got unbridled discretion and unfettered powers. Such an interpretation of Rule 31(1) would violate the basic tenet of Article 14 of the Constitution. And moreover, my lord, we will read Rule 31(1) in a manner so that it conforms to the basic golden principle of service jurisprudence, that there can never be a second inquiry. There can never be a second inquiry on the same charges of which charged officer was found not guilty in a previous regular inquiry. So, my lord, if this is how we read Rule 31(1), then the power exercised is arbitrary.
The other officer was fixed on this point.
Same. My lord, it was an inquiry. Both of them were charged officer. Inquiry was same.
File went to the DGP in connection with opening the.
Yes, the promotion. But he came to know about both. He fixed up both. Incidentally, my lord, so far as the other petition is concerned, mainly Guy, my lord might have just, off the record, my lord, I may inform your lordship, my lord must have heard the newspaper report that there was in a hospital very recently in Nahar Lagoon, one person suffering from insanity, possibly. He took a daw and started Sepa, my lord, he started killing the patients. So, five people were butchered by this person suffering from insanity, including a child, butchered in broad daylight. So, this gentleman, my lord, in fact, was on the spot. And three of his fingers were chopped off. He physically stopped him. So he's the person, the other one. It happened, of course, very, very recently, only a few days ago, maybe 10 days ago or 10 days ago. Anyway, that's a different point, just by the way. So he's Milli Gai, the other person. So, my lord, that practically is the case. I have given my submissions. My lord, if there is any doubt, my lord may keep it part heard, since in any case I'm coming on Tuesday, and this is a very short matter.
Mr. Toppin? No. Tuesday. Yeah. Tuesday.
Yes, my lord, because it's very short, there is nothing much in it.
So both the matters would be kept.
Yes, my lord, because they are similar matters, same order, my lord. The same order is impugned in both the cases, because by the same order, both of them were fixed by the DGP. Rule 31(1) has to be interpreted by your lordship. What is the limit of the power? How power can be exercised? My submission would be power cannot be exercised in a manner so as to confer him with the discretion of initiating second inquiry on the same charges. And secondly, my lord, he appoints an inquiry officer also, which he could not have done. And thirdly, he stops the promotion. He had no authority under the law. DPC is a statutory body. DPC gave its recommendation because since, my lord, he has started an inquiry, so obviously the person also could not be promoted. So that has also been affected.
Third, Mr. P.K. Deval, Learned Senior Counsel, assisted by Mr. K. Saxena, Learned Counsel for the petition. And also heard Mr. S. Toppin, Learned Senior Government Advocate for the state respondent. Heard in part, list the matter on Tuesday.
Yes, my lord. My lord, part heard now that it is, there is nothing much, so it will be part heard only.
Yes.
Yeah, yes.
Heard in part. Let's list the matter as part heard.